We'll call this meeting to order for Management Audit, July 9th, 2025. Would you please take roll?
Senator Ide.
Here.
Senator McCune.
Here.
Senator Olson.
Here.
Senator Rothfuss.
Here.
Senator Smith.
Senator Smith will be arriving late, so let's keep roll open.
Representative Lean.
Here.
Representative Locke.
Present.
Representative Rodriguez Williams.
Here.
Representative Sherwood.
Here.
Vice Chairman Larson.
Here.
Chairman Knapp.
Here.
Mr. Chairman, you have a quorum.
Thank you. Welcome, everybody. Hope you had a good 4th. Happy birthday, America. This is Management Audit, and if you're attending, if you didn't yet, would you please sign in so that we know you were an attendee? As usual, we'll go through the chair, quorum rules, and also the decorum. Just keep things respectful, as we all know. So we'll get started. For the first item is our major administrative rules. And Mr. Petrie.
Morning, members of the committee. Just as a little bit of background, this of course was the topic that we spent the most time on when we first met in Casper back in the early part of May. There were a couple of things that—
Matt, is that mic
Yes.
on?
Yes, it is.
Maybe a little closer.
Okay. Is that a little bit better?
Yes, a little bit. Yeah, thanks.
Okay, very good. Again, a couple of things that came out of the meeting that we had on this topic in Casper back in May. There was a discussion about legislative ratification of administrative rules. And we had done some background work on states that currently require that. There are a total of 8 states that have a program or an approach to approval of administrative rules similar to what the state of Wyoming did with Senate File 127 in this last session. 2 of those states were Kansas and Florida, and in our research, those were the 2 states that essentially offered the most information that we could potentially use to consider any potential changes to the legislation stemming from Senate File 127. Again, the 2 states that we looked at most closely were Florida and Kansas. Florida has had an effort or an initiative, if you will, similar to this for over a decade. It has evolved over that time period. Kansas has had something similar to what Senate File 127 proposed, but really it was just fully evolved, fully baked, quite frankly, as recently as 2024. But there were some questions that arose about legislative ratification of administrative rules specific to those 2 states and their approaches. So the very first document that you have in your packet this morning is a research memorandum entitled Florida and Kansas Legislative Ratification of Administrative Rules. I certainly don't want to read the document to you. I think there's a lot of very good background in terms of the different types of legislative ratification of administrative rules, what Florida has specifically, and the makeup of its legislature. You will see there's a reference toward the bottom of page 2, the staffing level at the state of Florida for the Legislative Service Office. The equivalent of the Legislative Service Office in Florida is just shy of 1,500 employees, 1,448. They have 11 individuals essentially dedicated to their regulatory impact analysis function, so a little bit less than 1% of their entire LSO staffing. I might ask you to jump to page 3 of your handout, to the very last paragraph. I think this is an important distinction, and really that's what I will do this morning, is I'll just draw your attention to those things that I think are most important for any decisions you'll be asked to make today. So if we look at that last paragraph, pursuant to Florida statute, only those rules that exceed statutory economic impact are subject to legislative ratification. So that's very similar to Senate File 127. Excluding emergency rules or rules resulting from a federal mandate. That too is something that we spoke about at our previous meeting, and there was quite a bit of discussion on potentially excluding emergency rules from the definition of major rules, as it was set out in Senate File 127. The one that didn't garner quite as much discussion at our previous meeting was a federal mandate, rules that basically stem from a federal mandate. But that is something that you'll see from the 8 other states that have initiatives similar to this. The majority of them do not only exclude emergency rules from their definitions of a major rule, but also rules that are driven by a federal mandate. Just moving along, the statutory threshold, again, this is in Florida, the statutory threshold is met if a rule will have an adverse impact on small business or is likely to increase direct or indirect regulatory costs in excess of $200,000 in the aggregate within 1 year after the implementation of the rule. That too is similar to where we were when we left the meeting in Lander in early part of May. Currently, that threshold stands at $1 million per year in Senate File 127, the legislation stemming from Senate File 127. There was discussion about dropping that to $200,000 per year, and then I think some subsequent discussion as to what might be the appropriate threshold. Moving on to determine whether a bill has essentially surpassed that threshold or a rule has surpassed that threshold, its impact. Agencies are encouraged to complete a statement of estimated regulatory costs for any rulemaking effort, which includes an economic analysis detailing its effect on businesses, small counties, and small cities. Estimates of how many businesses or individuals must comply, and a description of regulatory alternatives, as well as any other information an agency believes to be relevant. Again, this was something that we touched on briefly when we met in early May, was agency involvement, to put it simply. As it stands now, the Legislative Service Office would essentially conduct an analysis of all administrative rules, whether it's a new rule or an amendment to an existing rule, to determine whether it satisfies that economic threshold. If so, then obviously we would continue on with the regulatory impact analysis. If it does not satisfy that economic threshold, then the process would end for those administrative rules. Florida, and we'll touch on this a little bit more as we move through the document, certainly true with the majority of the other states that have initiatives like this, is that it asks agencies to provide some of that information, quite frankly, to do some of that legwork on the front end. So you engage with your stakeholders, you engage with those entities, those individuals that are impacted by your programs and your promulgation of administrative rules, and give us some information on what those impacts will be. Basically asking them to some degree, tell us whether their rules surpass that economic threshold that makes this a major rule, and then then it would require the regulatory impact analysis. So again, what it does, at least in Florida, is it puts some more of that responsibility on the agency that's attempting to promulgate those rules or that is required to promulgate rules by statute, rather than having LSO do that, only to find that a rule may not surpass that threshold and then the process just stops. You'll see that as kind of a common thread as we work through some of these documents. This statement of estimated regulatory costs that agencies in Florida prepare when attempting to promulgate rules, that is the primary indicator of the need for legislative ratification. So again, agencies, when attempting to promulgate rules, are telling essentially the legislature and the executive branch, the governor's office and LSO, whether the rules that they are attempting to promulgate require a regulatory impact analysis. If we, I'll just touch on something very briefly on page 5. I had indicated that in Florida, their legislative service office, or the equivalent of their legislative service office, employs 1,448 people, 11 full-time staff involved in regulatory impact analysis. In Kansas, much smaller office, obviously, for the equivalent of their legislative service office. They have 152 full-time employees. Of those 152 full-time employees, 8 of them are directly responsible for regulatory impact analyses. So percentage of staff dedicated to this in the state of Kansas is about 5%, a little bit more than 5% of their total staff, whereas in Florida, the percentage was much smaller. But in terms of raw numbers, we're talking, between those two states, you're talking anywhere from 8 to 11 individuals engaged in this initiative. Starting at the very last sentence on page 5, before you get to the footnotes, I'll just touch on a couple of things here for, again, this is state of Kansas. According to the 2024 JCARR, that stands for Joint Committee on Administrative Rules and Regulations. That's essentially the body in the state of Kansas that looks at administrative rules to determine whether a regulatory impact analysis is needed. That committee met 9 times between July 2023 and June 2024 to hear from state agencies proposing rules and to recommend action. JCARR is supported by, again, 8 legislative staff. So the question that came up when we met in May was, first of all, when do legislatures meet in Florida and Kansas? And there's some background there. But what you see, especially in Kansas, is that they have this committee, this joint committee, that has a very significant role in review of administrative rules. And what they have then is they have the ability for this committee to call meetings to bring agencies forward to essentially offer testimony, to answer questions on the rules that they would like to promulgate. And so they call those meetings periodically. And again, in essentially a 12-month period in the state of Kansas, that committee met 9 times. I think that's an important distinction because if Wyoming were to go with legislative ratification of rules, you would have to have something like this in place in order to do that in a relatively timely fashion. If an agency is required to promulgate rules, let's say that a new statute is enacted that requires an agency to promulgate rules, then if it requires legislative ratification, those rules would basically be in limbo until the legislature met the next winter. So you could see delays, very significant delays of, in most cases, a minimum of 9 months. In Kansas, they've addressed that with this joint committee that meets periodically throughout the year to address rules proposed by agencies in a much more timely fashion. So again, just something to keep in mind should Wyoming want to do that. I'm going to touch on the rest of page 6 pretty heavily because I think that that's really the meat of this document under the heading Rulemaking Statutes and Ratification. So legislative ratification requirement for proposed rules exceeding an economic impact threshold of $1 million in the first 5 years of implementation, excluding temporary emergency rules, federally mandated rules, or rules of the Kansas Agricultural Remediation Board. So again, this is specific to just Kansas, not Florida, but they have a $1 million first 5 years of implementation. So if we do the math, that's an average of $200,000 per year, which is essentially where we are today in terms of what was asked for in the changes to the bill draft. But again, they do exclude emergency rules in Kansas. They exclude federally mandated rules from the definition of major rules that would need to be considered by the legislature. And then, for whatever reason, rules of the Kansas Agricultural Remediation Board. I cannot offer a great deal more information on that, although they apparently were effective in gaining a waiver from this process in the state of Kansas. That's something that we didn't really see in the 6 other states was exemptions for essentially entire state agencies. So definitely the exception, not the rule. Moving on to the second paragraph under that heading, when an agency determines rulemaking is necessary and begins the drafting process, the agency is required to consider the economic impact of the proposed rule and prepare an economic impact statement. So again, agency involvement on the front end. Agencies are directed to prepare the EIS, or Economic Impact Statement, by consulting with affected parties such as municipalities or local government entities, businesses, associations, or other interested parties. Again, just reiterating to some degree the fact that agencies are going to be a little bit closer to the parties affected by their programs than the Legislative Service Office staff. Moving on to essentially the second to last paragraph on page 6, an economic impact statement is required to include cost and benefit quantifications, intended accomplishments of the rules, analysis addressing enhancements or restrictions on businesses, economic effect on specific sectors and the state, businesses that may be directly impacted, measures taken by the agency to minimize costs, and an estimate of total annual implementation and compliance costs. Once that economic impact statement is complete and both the Kansas Secretary of Administration and Attorney General approve the proposed rulemaking, the agency submits the draft rule and the economic impact statement to the Kansas Department of Administration Director of Budget. So this is an additional step in Kansas. I don't think that when we reference the Kansas Department of Administration Director of Budget, I don't think that that's a position that's equivalent to, say, Kevin Hibbard's position in the state of Wyoming as the Director of the Budget Department. It is a position that was created essentially to be kind of the original arbiter of administrative rules and whether they surpass that threshold and need legislative ratification. So that individual in the state of Kansas then can make a call. And just continuing on, this Kansas Department of Administrative Director of Budget is required to conduct an independent analysis and confirmation of the EIS. The Director of Budget has a variety of options. They can either return the economic impact statement to the agency for corrections if it's incomplete or it's inaccurate. They can confirm the proposed rule does not meet the EIS threshold. Again, in Kansas, that would be $200,000. It would confirm that it does not meet the EIS threshold, and then basically just give the agency the green light to move forward with rulemaking, or confirm the proposed rule will exceed the threshold. In that event, in that event that the rule does exceed the threshold, the Director of Budget informs the agency of the option to revise the rule. So the agency is given another opportunity to basically revise their rule so that its impact may not be as great. Or the agency can simply continue with the path that they're on and ask that the legislature ratify the rule's substance through enacting legislation. But again, if it reaches that stage where it's past all those hurdles, if you will, then it essentially goes to the legislature, but in Kansas, it goes to this joint committee that met 9 times in the last fiscal year to basically hear from the agency itself. So that's essentially the research that we conducted on legislative ratification of administrative rules. But very specifically focusing on Florida and Kansas because those were, quite frankly, our 2 best examples. And the 2 state agencies that had enabling legislation that was the most similar to Senate File 127. Just one more point, page 7 of your handout. In Kansas, the legislature, while in session, may adopt a concurrent resolution expressing concern about any rule on file with the Secretary of State, thereby requesting revocation of the rule subject to the governor's approval or veto. So that too is similar as what we have driven by Senate File 127, that the legislature can basically request a resolution essentially negating that rule. The only difference is that in the state of Kansas, that recommendation that rule basically be rescinded, that it be essentially eliminated, then goes back to the governor for his or her approval and or veto. So the administrative in Kansas, you've got a process where agencies are more heavily involved on the front end in terms of providing information as to whether it crosses that economic threshold. So it should receive a regulatory impact analysis, analysis. And then as it basically makes its way through the entire process, the governor's office still has some say at the very tail end of the process in terms of his final approval or veto. So that is the information that we put together in terms of legislative ratification. I won't touch on the appendix to this document, but I think it's a very nice, very informative appendix document that really touches on the processes, the economic thresholds, the rule review committees, the way that they're structured, and the ratification process for the 8 states that have actually approved initiatives like this, similar to Wyoming. And those states, in addition to Florida and Kansas, are Indiana, Kentucky, Oklahoma, Utah, and Wisconsin. Mr. Chairman, at this point, before moving on to our next document in your packet, I might stand for questions.
Thank you, Mr. Administrator. Hopefully you didn't salivate too much when you saw the 1,500 employees for Ellis.
Mr. Chairman, I did not. I just came from an agency with 1,500 employees. It's called Health in Wyoming.
All right, any questions from the committee? Representative Lean.
Thank you, Mr. Chairman. Thank you for this detailed research. I'm curious how the fiscal notes that we currently receive with tentative legislation is different than what is mentioned here on page 4, paragraph 1, and on page 6, under the rulemaking process.
Mr. Chairman, Representative Lean, that's a very good question, and actually something that we looked at, because what we had done when attempting to address what the staffing would look like in the state of Wyoming, what we wanted to do was we went to the Secretary of State's website. We looked at 2 fiscal years of rules that were, that were promulgated. And what we were hoping to find was then we could see which statutes required promulgation of those rules. We could go back to the statute, we could look at the appropriation, we could also look at the fiscal note, and that would give us a fairly clear indication of what, basically what the economic impact was from the agency's perspective. Unfortunately, what you have is that especially with the Secretary of State's offices, that you have access to those rules that have been promulgated, so you can back into the legislation behind behind those rules. But what you'll find with fiscal impact notes is that they typically they don't always offer as much information as you would like, and that's certainly not a criticism of the agencies themselves. When they look at draft legislation, and they will put together a fiscal impact note of impacts to, say, industry, the public, they will also put together an administrative impact statement that shows impacts to the agency itself. Thank you. And so we looked at that because basically what we wanted to do was we wanted to gauge how many of the bills that were filed with the Secretary of State's office would have passed that regulatory threshold, and so we'd have a good idea of what the workload would be. But what we found is that, again, with these regulatory impact analyses, they're not just required on new rules. So if the legislature passes a bill that essentially establishes a new program, you will have that fiscal impact statement. But agencies can also promulgate rules that aren't driven by statute. There may just be a change in the way or the environment that they operate in, and they need to amend their rules. And so it's not a very good indicator of what the economic impact will be. It's always there for new legislation, new rules, but seldom there for amendments to existing rules. But you're exactly right in that what we would be asking of agencies would be an expanded version of a fiscal impact note. The only other thing that I might offer is that fiscal impact notes, of course, are done when a bill is introduced. And so the agency typically they know what's directly in front of them. What does the introduced legislation look like, and what impact would that have? What you'll find is that, and this is even true during the session, that fiscal impact notes kind of serve their purpose at the front end. So when you've got bills that have been introduced, but if there have been amendments to bills, fiscal impact notes really lose some of their value, their effectiveness. And so as a piece of legislation makes it all the way through, all the way to an enrolled act, fiscal impact notes are fairly, they're of limited use, less use. So what this would do is it would basically be asking agencies to essentially go through that process again, but in more detail after the legislation has passed. Or they know exactly what kind of amendments need to be made to their rules, not driven by statute per se, but just because of changes in economic conditions, environmental conditions, so forth.
I had a follow-up question to that. So time frame wise, just so I'm clear, when a bill or when a law becomes enacted, which typically is your July 1st, is there a time frame to then devise rules, go out for comment, to catch that next session, or would it be too much of an abbreviated process?
Typically especially again, if we look at Kansas as opposed to Florida, I think Kansas is probably a little more representative. What they will do, again, an agency is going to be required to promulgate rules. They will draft those rules. At that point in the process, they will go to, again, this director of budget and to the Attorney General's office. If they feel like kind of the same process that we do now, where LSO checks for, are the rules consistent with intent? Are the rules constitutional? Basically the legal aspects of the rules. If they clear that hurdle, then it goes to the Director of Budget. The Director of Budget takes a look at it. And if it appears to them that it requires a regulatory impact analysis, then it goes to this committee, this joint committee in the state of Kansas. This joint committee calls a hearing periodically, again, 9 times in 1 year in Kansas. They bring the agency in for testimony. The agency testifies on their rules. And then at that point, the legislature decides whether to proceed with that regulatory impact analysis. And ultimately, the rules will still have to go to the legislature for ratification. But in Kansas, basically you've got that joint committee that's kind of an interim step that makes the call on whether those rules have been ratified.
Yeah, I'm just wondering if that 5 months is a good period to catch that next session for ratification, or?
I think that typically, again, and this was something that we touched on in our previous meeting in Lander, right now, in most cases where agencies, a new law is passed, with an effective date of July 1st, agencies are required to promulgate emergency rules in order to be able to implement that program on July 1st. The regular rules are still making their way through the process. Keep in mind that emergency rules do not require public comment. That's why they can be implemented so much faster. It's really just the governor's approval at this point. So in Kansas, what will happen is that consideration by this joint committee will occur at the same time that public comment is being taken. And so the two processes kind of overlap. I think you're still going to have instances where emergency rules are necessary, and both Kansas and Florida recognize that because they exempt emergency rules from the definition of major rules. But then the regular rules still work through that process. But I think Kansas recognizes that if they're going to require legislative ratification, that it needs to occur more often and certainly more quickly than waiting until the next session, if those sessions only occur once a year. And you'll probably, the reason why Kansas has done this 9 times in 1 year is you're just going to have agencies, especially with existing programs, as they amend their rules, they're not always shooting for a July 1st effective date. It could be any time within the year, but again, there is some level of urgency there to get those rules in place. And so that's, again, I think Kansas's attempt to essentially go forward with legislative ratification, but do it in a timely fashion. As it stands right now, under Senate File 127, what happens is that administrative rules, regular rules that have public comment, they still go to the governor for approval. The governor approves those. They go into effect, essentially replacing the emergency rules that are already out there. And then the legislature, after this regulatory impact analysis is finished, then the legislature, and when I say legislature, it's actually any individual legislator, any committee, can then basically ask for rescission of those rules at the next legislative session. So in Wyoming, that's why there is no legislative ratification. The governor still approves rules, they go into effect, just as management council does now. Management council could basically bring or recommend legislation in the next session that essentially negates a rule. Fairly rare that happens because there are so many procedural checks ahead of that. But it does exist now. what would happen under Senate File 127 is the individual legislators and legislative committees would have the ability to propose rescission of a rule. But again, you would have to wait until that next legislative session under Senate File 127.
Okay, thank you. Other questions? All right, we'll
Very
let
good.
you go get a very good drink of water.
Okay, thank you. Yeah, let's jump to the next handout in your packet. It is called 2025 Senate File 127 Amendment Options. And what this is basically a continuation of the discussion that we had in Lander in the early part of May. Again, Senate File 127, there is a requirement in Senate File 127 that a report be provided by Management Audit Committee to Management Council no later than December 1st, recommending changes, potential changes to the law enacted by Senate File 127. Obviously, there could be no changes recommended. There could be a significant changes recommended. But we started that conversation in Lander in May, and some questions arose, and so we wanted to provide some additional information on those. You had also asked for a bill draft with some of those discussions and some of those decisions that were made in Lander in May. And Mr. Anderson will touch on those after this presentation. He will actually walk through that bill draft that was requested. And what you'll see is some pretty significant overlap between what I'm about to present to you in terms of potential considerations for the committee and what Mr. Anderson has included in that bill draft, and we've noted that here. So if I may, I will step through this fact sheet. Again, I'm not going to go through the entire thing. I'll just touch on those things that I think are the most pertinent to this discussion. There are 5 options that we would ask the committee to consider, and they're listed here individually. So if we jump to page number 2, you will see just below those enumerated items, Romanet 1 and Romanet 2, there's a statement that says, although Senate File 127 states that major rules are designated by Management Council, the Act does not provide a mechanism for such a designation. So the first recommendation, or at least suggestion, is that the Management Audit Committee could consider deleting the designated by Management Council language from the definition of a major rule as proposed in 2026 LSO 0106, page 3, line 19. So that is a reference to the bill draft that Mr. Anderson will cover in just a minute. So what we've got here is we've got essentially something for you to consider. You'll see in the next presentation that that is actually incorporated into the bill draft. If we move into the next portion of this document under the heading Economic Impact Threshold Criteria, the Senate File 127 definition of a major rule includes 2 criteria. The first criterion, an annual impact on the state economy of $1 million or more, is potentially measurable. The second criterion, which is literally significant adverse effects, is not nearly as potentially measurable. In the previous presentation, I had indicated that we've got 8 states that have some form of legislative ratification of administrative rules. We also have, I believe it's 8 states as well that have Raines laws. Raines laws are, I forget exactly what the acronym stands for, but basically they are laws. Raines laws are laws that have been proposed at the federal level for administrative review of rules. They have been proposed essentially 5 or 6 times at the federal level, beginning in, I believe it was 2009. Those proposals have always passed the House at the federal level, but have never passed the Senate. And so while there are attempts to essentially impact or implement this type of process at the federal level, they have not passed so far into law. However, we do have a number of states that have adopted that methodology. They take that federal model and then they adapt it for their own state. And again, I believe we have 8 states total. 5 of those states that have adopted this kind of federal model, these RAINS laws, including Indiana, Kansas, Kentucky, Oklahoma, and Wisconsin, use that measurable criteria only. That criteria that I just touched on, the first of the 2 that's outlined in Senate File 127. These 5 states set their economic impact thresholds according to established or estimated implementation and compliance costs. Kansas and Oklahoma provide further specificity by then defining implementation and compliance costs. So what they do, these 5 states, is they essentially narrow what it is, those costs, those financial impacts that are considered when they're looking at something to see whether it's crossed that threshold. In Kansas, $200,000 a year. But they've essentially added some definition to those things that they'll look at to see whether it passes that threshold. Moving on, the threshold for regulatory analysis or legislative review established by the 7 state RAINS laws range from $500,000 in implementation and compliance costs over any 2-year period. That's the case in Kentucky, or essentially $250,000 per year, to $10 million in costs over any 2-year period, $5 million per year. That's Wisconsin. So a very broad range that you can see there in terms of these economic thresholds that different states that have adopted this methodology use as the threshold to consider something a major rule. If we jump to page 3, what you'll see again a suggestion for your consideration stemming from that, from these, essentially these measurable impacts. Management Audit Committee could consider amending the Senate File 127 definition of major rule to include measurable criteria only, as well as more specific language such as implementation and compliance costs, what we just touched on, or a specified time period for measurement of the rule's economic impact. Here again, these suggestions, if you will, are included in the bill draft that Mr. Anderson will touch on here briefly. So something that we talked about before, this is really just a reiteration of the recommendation, the suggestion, and it is included in the bill draft that you'll consider here shortly. Let's talk a little bit about exempt rules. This is about the middle of the page, page 3. Wyoming Senate File 127 includes emergency rules in the definition of major rules subject to LSO regulatory impact analysis. 5 of the 7 other RAINS law states exempt emergency rules from regulatory impact analysis or legislative review. 4 of those same 5 states also exempt rules which are federally mandated. Utah exempt rules which are necessary to implement state statutes, while Kentucky exempts rules which are necessary to meet a deadline established by state law or to prevent the loss of state funds. So you see a little bit of variety there in terms of exemptions that these 7 other states have in terms of rules that are exempted from a regulatory impact analysis, but the majority of them exempt emergency rules as well as federally mandated rules. So again, a fairly common thread that we saw in our research in both areas, both ratification and then these recommendations. The suggestion for this area of concern is the Management Audit Committee could consider exempting from the Senate File 127 definition of major rule 1 or more of the following: emergency rules, federally mandated rules, and rules necessary to implement state statutes in a timely fashion or to prevent the loss of state funds. Again, that last bullet point there is really driven by some of the differences we saw in Utah and Kentucky. But at least the exemption of emergency rules in Wyoming, that too is something that's incorporated into the bill draft that Mr. Anderson will ask you to consider here shortly. Something obviously that we talked about a couple of months ago in Lander. Okay, our next area for consideration, regulatory impact analysis itself. Wyoming Senate File 127 requires LSO to complete a regulatory impact analysis of each major rule submitted by an agency for legislative review. The Wyoming law is unique in requiring that the analysis be conducted by legislative staff rather than executive branch agency staff. Each of the other 7 state reigns laws assigns responsibility for the regulatory impact analysis to the agency proposing a new or amended rule. So again, this just brings us back to the conversation we had just a few minutes ago under ratification that in the 7 other states that have initiatives similar to this, they expect the agencies to have a more active role on the front end. If you're going to propose rules, then tell us what those impacts are on the entities that your programs impact, on the public, on businesses, and so forth. So again, kind of going back to Representative Lean's question where you've got a fiscal impact statement at the beginning of the legislative process. This is on the end of the legislative process where the agency is attempting to promulgate rules to implement the statute, but you're then pulling the agency back in to help you determine just exactly what those impacts are. I think this is a really important point because that will occur regardless. The agency can either provide that information proactively on the front end, or as the LSO staff goes through the regulatory impact analysis, it's going to be reaching out to that agency anyway to get answers to its questions. And so it's not one or the other, it's really just which entity provides that information and the timing of it. The only real significant difference there is that I think that with Senate File 127, the way that it's structured currently is essentially every rule, there will be a presumption that it could be a major rule, that you will surpass that economic threshold. And so every rule, whether it's a new rule or a rule amendment, will have to have some type of regulatory impact analysis just to determine whether it hits that threshold. If it doesn't, we would drop it. The agency would proceed with promulgation. If it does clear that threshold, that's when we would finish that regulatory impact analysis and provide it to the legislature. In the 7 other states, they put, I don't want to say it's a burden, but they put that responsibility on the agencies. But again, it's their questions that are going to be asked of the agency, regardless of whether they do it proactively or LSO reaches out to them later. So with respect to this area, and just again, to touch on one other thing before I get to the suggestion on this concern, the very first sentence there on the top of page 4, agencies are often familiar or have contractual relationships with private businesses and local government stakeholders who will be impacted by proposed regulations. The Suggestion Management Audit Committee could consider amending Senate File 127 to require the agency proposing a major rule rather than LSO to complete the required regulatory impact analysis. Okay, that brings us to our last area that we would ask for your consideration of: legislative review of regulatory impact analysis. Wyoming Senate File 127 adds an economic impact analysis of major rules to the established longstanding legal review of permanent non-emergency rules. So keep in mind that LSO currently, and has been doing this for decades, basically looks at all rules, all regular rules, not emergency rules, for constitutionality. to ensure that the rules are consistent with the intent of the statute behind the rules, and that it's under that agency's authority to promulgate those rules. So very much a legal review, and that process has gone on for decades. Currently, all proposed permanent rules are submitted to LSO for legal review, as I just touched on, and the findings are reported to Management Council. Management Council can then make recommendations to the governor's office on approval. That's the way that the process works. If the governor chooses to move forward with rules that the Management Council may have had some concerns about, the Management Council can come back in the next legislative session and attempt to rescind those rules. So that's the current process. By contrast, Senate File 127 does not provide a mechanism for the Management Council to make recommendations based on the LSO regulatory review to the governor prior to adoption of the proposed major rule. So again, this is something that I touched on in the first portion of this presentation, that as it stands now, governor approves rules. Management Council can essentially come back in the legislative session and attempt to rescind a rule if it chooses to. But as it stands now, under Senate File 127, the governor is still going to approve regular rules. If he feels that those rules are necessary, he can approve those rules. They will go into effect. If the legislature has concerns about that rule based upon that regulatory impact analysis, it can come back in the next legislative session and propose rescission of that rule. And again, it would be any committee or any individual legislator can bring that proposal forward. So that's a fairly significant departure from the current process. The other 7 states that have RAINS laws require a proposed major rule and its accompanying regulatory economic analysis to be submitted for review to a specified legislative committee, such as an administrative rules review committee or budget committee, or to an appropriate committee with subject matter expertise. So again, this is something that we touched on briefly. In Kansas, this is that joint committee that I spoke to that had met 9 times in the last year. So they're the ones that, at least in the state of Kansas, where proposed major rules go to for ratification. There could also be an option to essentially send those major rules to standing committees, corporations, judiciary, whatever the case may be. But they too would then probably need some authority to meet more frequently so that they could consider rules in a timely fashion so that agencies could implement those rules and not have to wait until the next legislative session if legislative ratification were the direction that the committee wanted to go. So the final recommendation or suggestion here is the Management Audit Committee may want to consider amending Senate File 127 to require proposed major rules and the regulatory economic analysis be submitted to Management Council or another specified committee for review. Mr. Chairman, that is the conclusion of that document. Again, we do have an appendix very similar to the appendix that you saw for the first item in your packet. And what this does is it looks at those 8 states that have patterned their approaches after the federal RAINS law or the proposed federal RAINS laws. And again, you'll see just a breakdown for the states. You'll see the year that each of these states enacted these RAINS laws, these essentially administrative rules review laws. You'll see the economic impact threshold that's used by each one of these 8 states. If there are any exemptions from regulatory impact analyses in these other states, you'll see that as well under exempt rules. You will also see which entity conducts the initial regulatory economic impact analysis for each of those 8 states. You will also, there's a column there summarizing legislative review of regulatory analysis because it can differ from state to state. And then just the statutory reference to the law that was actually enacted to initiate that process. So I think very good summary information. I won't touch on it here, but I think it's a nice reference. to get the picture across all 8 states.
Thank you very much. Senator Ide.
Thank you, Mr. Chairman. I just have a question on, I'm always nervous when I see emergency rules, emergency declarations, those sorts of things. Always seems like citizens lose a lot of liberty when those things are instituted. Can you qualify or quantify how emergency rules are determined? Thank you, Mr. Chairman.
Yeah. Mr. Chairman, Senator Ide, absolutely. Emergency rules typically, when you have new legislation passed, it will have in some cases, it'll be effective immediately. But in most cases, you're looking at July 1st of the year following the legislative session. So when we had a new bill that passed out of the 2025 session, the effective date of that legislation will generally be July 1st of that same year. So what you see is that, and then in statute, a lot of times when a new law is created, statute will specifically direct that agency to promulgate rules to implement that. So, think of statute as essentially below the Constitution in terms of authority. Then you've got statute. Below that are administrative rules. Administrative rules are legal. They carry the same legal authority as statute, but they obviously sit at one level below. They're more granular in nature, so they provide the information that entities that are impacted by a law can use to see how that law is actually going to be implemented by the agency. Below that, obviously, you have policies. Policies can be changed on a day-to-day basis by the agency. So rules sit directly below statute. But what you have with most statutes is, especially when a statute requires an agency to promulgate rules, there simply is not enough time to promulgate regular rules prior to July 1st. So you've got this mandate that the agency has to have rules in place by July 1st, but the regular rules process takes too long, is too extensive in order to hit that July 1st date. So you implement emergency rules, and typically emergency rules and regular rules are mirror images of themselves when the agency puts them together. The emergency rules go to the governor for his signature. They go into effect, but the very second that regular rules are approved by the governor, the emergency rules are essentially eliminated. But keep in mind that regular rules, and there's good reason for regular rules taking as long as they do. You have to have public comment. You want public comment. You have to have review by the Attorney General's office. The governor's office has time for their own review. And so there are a number of steps there. And typically, just as kind of a general rule, regular rules will typically take an absolute minimum of 130 days to implement. Regular rules, ironically, are good for 120 days. So what you will typically see is that regular emergency rules are enacted, promulgated. That'll get you close to the point where your regular rules take over and replace them, but you'll typically need an extension of your emergency rules just to kind of bridge that 120 to 130 day minimum. But again, regular rules completely replace emergency rules. There can be considerable differences in regular rules from emergency rules once the regular rules have gone through the public comment period. So they typically look identical out of the gate when the emergency rules are approved. They can look considerably different, regular rules can, by the time that they're actually promulgated by the agency because of public comment. And so really emergency rules are really just necessary because of the timing of new legislation. And legislature obviously in enacting new laws wants those laws enacted appropriately with the proper timing, and typically it is July 1st. And so you've got those emergency rules for the agency to do what they need to do on July 1st and then wait for the regular rules to kind of wind through the process. You bet.
Any other questions? Yes, Representative Lean.
Thank you, Mr. Chairman. I want to take you back to where you keep saying that the governor reviews the rules In Article 4, Section 14 of our Wyoming Constitution, the examination of accounts is given specifically to the legislature. In my research, I found from 1971, 1973, 1975, let's see, 78, 84, 95, 2002, 2005. Anyway, the point is, I can't find in any of this legislation where we have given the authority for rulemaking to be given to the governor. Could you please tell me where that is located?
Mr. Administrator.
Mr. Chairman, Representative Lean, I may defer a bit to a document that you'll find later on in your packet that addresses that question. That was a question that was raised during our meeting in Lander in May. I think that in essence, I think what it comes down to, whether it's the state of Wyoming or whether it's another state, and we've talked about 8 other states that obviously all states are dealing with administrative rules because you need those in order to implement legislation, which is typically more general in nature. But in all of those states, the governor does have a role. And it has to do with separation of powers. But I think it also, more importantly, is the entities that must implement and carry out legislation after it is passed are executive branch agencies. And so there is certainly an opportunity for the legislature to consider rules currently, but the governor's office is approving those rules because those are the rules, the policies, if you will, that are being carried out by executive branch agencies.
Follow up?
Yes, Mr. Chairman, thank you. Thank you for that. I will look further ahead, but when I was reviewing my materials, I didn't see that. As I wanted to go back to Session Law of 1977, where it says, let's see, I'm in Wyoming Statute 2876A, and it says, it shall be the duty of the legislative auditor under the direction and the supervision of management council and the subject to their priorities and subject to general policies established by the legislature. So when we're talking about creating this legislation, I'm curious to know where the governor's act, or where the governor's role comes from. And I heard what you said, that we're going to get to that in a little bit. But I think it's important that when we're talking about amendments to this legislation, that we understand what the governor's role is specifically and how to use it. So my question would be, moving forward, do we need to amend in a specific role for the governor into this legislation?
Mr. Administrator.
Mr. Chairman, Representative Lean, again, I may defer to Mr. Anderson on this question from a legal perspective. As it stands now, we would, the governor's office and the governor himself still has the authority to promulgate rules, to approve regular rules. They go into effect prior to any opportunity, if you will, for the legislature to propose rescission of those rules. So the regulatory impact analysis occurs and is concluded after the governor has had an opportunity to implement a rule, a regular rule, and promulgate it fully. The legislature at that point in the next legislative session has the ability to go back and propose rescission of that rule. Management Council still has that ability now. But as it stands now in Senate File 127, the governor's office, it has not changed the governor's authority to approve regular rules in the same time frame as he currently has. If you would have to, I would assume, and again, I would defer to Mr. Anderson, you would have to change statute, I believe, in order to change that path, if you will, that rules take, where essentially the governor is the last step and he approves those rules. you would have to replace that in some form with legislative ratification in the absence of the governor's approval.
Representative, follow-up? Matt, in this, what do you see LSO's role? Because when we talk about review of economic impact, regulatory impact, there is somewhat of a checks and balances there between legislature and agency. So what do you see as the LSO's role in that? Should it be jointly working on those impact analysis? Or should it be that quasi-committee that would be put together to adopt rules throughout the year if possible? What do you see LSO's role?
Mr. Chairman, LSO's role really, whether agencies are required to provide more information on the front end or they are not, but then LSO would approach them on a rule, not only to determine whether it surpasses that threshold and is then a major rule, or even if that determination has been made that it surpasses that, let's just say it's a $200,000 annual threshold, LSO would still likely have to approach that agency to have some of its questions answered. So there will always be that level of coordination and cooperation between the executive branch and LSO, regardless of when those questions are answered. They're answered proactively by the agency, or they're answered essentially retroactively by questions from LSO. I think the benefit to having agency involvement on the front end is that it eliminates those rules that LSO would not have to look at to even determine whether it approaches that threshold. I think that, and you'll see in Senate File 127, I believe there's some language there that requires that agencies work with the Legislative Service Office and its regulatory impact analysis function in completing these regulatory impact analysis. So that cooperation, that collaboration between executive branch agencies and LSO staff is currently required. It would just, take on we would put some meat on the bone, so to speak, in terms of how that looks. But really, what happens if an agency were to provide more information on the front end, what they're doing is they're essentially helping with the determination of whether one of their sets of rules surpasses that threshold and is truly, at that point, they're major rules. So they are telling to you, they're proving to you that this is not a major rule because our impacts are, let's say, $100,000 a year. Or they're saying, yeah, we understand this is a large set of rules with a large impact and it surpasses that threshold. At that point, we know that it is a major rule, and then LSO staff would work to consider alternatives and to take that analysis further to provide to the legislature in order for it to determine whether it wants to challenge those rules in the next legislative session or not.
Okay, thank you. Mr. Anderson, do you want to address Representative Lean's question?
Sure, Mr. Chairman. So just briefly, there's a document in your materials dated 6/25 titled Administrative Rule Promulgation. It just has a brief kind of history of the Administrative Procedure Act, as well as some additional kind of background information. So you'll see that kind of at the beginning there, just kind of talks generally about why the legislature may delegate rulemaking authority to agencies, such as just complexity of the area of the law, agency expertise, frequent changes in that area of the law, the need for flexibility, and in general, just due to the lack of time to lay out complex issues in bills in the limited legislative session time. I mean, you'll see there that once rulemaking authority has been validly delegated, it becomes an executive branch function. You can see a quote from a case there that once the legislature makes its choice in enacting legislation, its participation ends, and the legislature may not unilaterally control the execution of that rulemaking authority after that delegation of rulemaking power. Over on to the second page, you'll see that that doesn't mean that the ability of the agency to adopt rules is unlimited. First, it's enacted, or it's governed in Wyoming by the Administrative Procedure Act, starting in 16.3.101. That does provide that no state agency rule may be filed with the Register of Rules unless it has been submitted to the governor for review and the governor has approved and signed that rule. And that does not change with Senate File 127. That remained the same. It does say that the governor shall not approve any rule until the date of receipt of Legislative Management Council's recommendation under 28.9.106 or 40 days after the rule is filed. The APA was created in 1965. At that time, there was not a specific mention of either the governor review and signature or any review by the legislature. It appears that it was primarily just a function of the agency. They would adopt those rules and file them with the Attorney General and the Secretary of State. In 1977, the APA was amended to require the governor's review, signature, and approval before the rule could become effective. At that time, the legislative review process was also added, providing for the review by Management Council and recommendations back to the agency and the governor. The governor was required to either accept the recommendations of Management Council or file his objections to those recommendations, and that process has remained largely the same since that time. If the legislature does not agree with an enacted rule, the legislature can sponsor a legislative order to prohibit the implementation of the rule. It's adopted in the same manner as other bills. Also, what the legislature can do is amend or revoke the rulemaking authority that is used to adopt those rules if they disagree with the rules. And then finally there, it just talks about also, in addition to that legislative review, rules can also be subject to challenge in the judicial system. They use an express delegation standard to review the rules. In a recent, or a 2001 case, the Supreme Court determined that Department of Health had exceeded their statutory authority and said that as a creature of the legislature, an administrative agency only has only the powers granted to it by statute, and the justification or exercise of any authority must be found within that applicable statute. So that was that brief memo, Mr. Chairman. I'd take any questions.
Questions from the committee? Okay, none.
And then, do you want me then to go into the bill, Mr. Chairman, or did you have anything else, Mr. Petrie?
Are there any other questions? You know, I think we should just go ahead into your bill draft because it incorporates those 5 areas of amendment options. And we can kind of cover each one of those if there's questions from the committee on those sections.
Sure. Sure thing, Mr. Chairman. So you'll see it's 26 LSO 106, Working Draft 0.4, was requested at our last meeting to make some revisions to the major administrative rule review process that was implemented in last year's Senate File 127. You'll see the first change at the bottom of page 2. What this would do is add a requirement for the agency when they're doing their rule promulgation, when they provide the notice of rulemaking, to include in that a new subparagraph M, that if the rules are major rules, it has to provide notice that those rules are major rules, a statement that they are major rules, a statement of the need for the major rule, and then any additional information necessary for that regulatory analysis required by 289109. Also, you'll see on page 3, it specifically requires the State Registrar of Rules to adopt rules necessary to ensure that the state agencies provide that information necessary to undertake the regulatory analysis required in 289109. The next change, Mr. Chairman, is at the bottom of page 3, the definition of major rule. This does essentially two things. First, as was discussed in the document that Mr. Petrie went through, it would remove the emergency rules from what would be considered a major rule. So it would just be the final rules. And then also it removes that designation by Management Council for a major rule, so that then now, as was just noted, the agency will make that initial determination of whether or not the rule is a major rule when they provide their notice of rulemaking. On to page 4, Mr. Chairman. You'll see there that currently the statute provided for a direct or indirect cost of not less than $1 million. This changes that to $200,000 per year. So it makes it clear that that's an annual determination of $200,000 on impact. Then you'll see the rest of the bill, Mr. Chairman, is just two staff comments. The first one is related there to that paragraph 2, the significant adverse effects on competition, employment, investment, productivity, or innovation in the state. So the first comment just says, with the clarification of the annual economic impact, the committee may want to consider whether paragraph 2 is necessary. Paragraph 2 does not include measurable benchmarks, which may make it difficult for agencies to apply in determining whether a rule is a major rule. And then the second staff comment is kind of related to some of the discussions earlier, essentially on the timelines. If the committee were to consider adding a requirement that the legislature approve the rules before they could become effective. So you'll see there, essentially there's some timeline questions. So on page 5, in that little subsection A, things that could be considered. Number 1, potentially delaying the effective date. So right now, average piece of legislation, we might make it effective July 1, but we might make rulemaking authority effective immediately so that the agency can have their rules in place by July 1. As Mr. Petrie noted, that can still even be a challenge timeline-wise, and they may have to do emergency rules to meet that July 1 deadline. So if the legislature were to require approval of rules first, that would essentially be the next session. And so you could either delay the effective date of most legislation until the conclusion of that following session, so it would delay things a year. Subsection B, you could also consider extending the ability to do emergency rules. So you could, right now, emergency rules can only be effective for 120 days, and then they can do it a second time, so that would be a total of 240 days. But that would not get you to the next, potentially not get you to the next legislative session to have approval of the final rules. So you could consider extending that out. And then subsection 2 would be another potential alternative that could be considered. And again, that would be similar to Kentucky. You could do it on a case-by-case basis, where if the legislature said the rules need to be effective by July 1 or January 1 before the legislative session, then those would be exempt from major rules because they would need to be done to meet a statutorily or legislatively designated timeline. And then if not, you could delay the effective date of the rules pending legislative approval. And then finally, number 3 on page 6, Again, just a note there, some courts in other states have, depending how it's done, they have invalidated the veto of power over rules as a violation of separation of powers. So if the committee was looking to take this approach, depending on the details that the committee was looking at, we would provide some more information on and more analysis on whether that would potentially have any impact on separation of powers issues.
Thank you, Mr. Chairman. I have a couple of questions, kind of the implications on this. When a law goes into effect on July 1st, that statute we've put in place is the law of the state of Wyoming, whether rules are in place or not. Is that correct?
Mr.
That's true,
Anderson?
Mr. Chairman.
So in the absence of rules, the executive branch is still obligated to carry out the law. It's just there isn't necessarily any guidance in some of the nuances on how to carry out that law, but it still doesn't obviate the law in any way. Is that accurate?
Mr. Anderson?
That's correct, Mr. Chairman, yes.
So in the absence of rules, what happens if we keep denying rules and say these rules aren't good enough, these rules aren't good enough? What does the executive then do, even as they're obligated to carry out the law anyway? Do they just kind of make it up as they go along?
That's a good question, Mr. Chairman, and certainly, I think, it'd be case by case on, how much is laid out in the statute versus how much is put to rules and whether or not they could administer that program or whatever it is without the rules. So I think it's, it's a hard question to consider in the.
Mr. Chairman, have any of the other states that we've been looking at here that have passed this legislation kind of run into this problem? Because, if you're an executive in one of these states and they're saying, well, we don't like these rules as the legislature, and they're making life difficult. Candidly, if I were the governor of one of those states, I would probably just stop promulgating rules. That seems like the easiest answer is just don't worry about it anymore. Carry out the law as you see fit, talk to your agencies, and then you're without rules. So I'm curious if we've seen any response like that, or how this has gone in other states when they've taken that executive role away from the executive. Why does the executive wait and listen and respond?
Mr. Anderson?
Good question, Mr. Chairman, and I don't know if we have any examples of that. We can certainly do a little looking. I would say that, one of the options would be similar to Kentucky, where if the legislature had set a deadline before the next legislative session, then those rules would be exempt from the major rule process and would not need to be go through the analysis or the approval. So essentially would let them do kind of case by case, which programs need legislative approval for the rules and which do not. And some states that were listed do take an approach kind of similar to Wyoming's existing approach, where it's still just a recommendation from the legislature from that committee, but the governor still can approve, and then the legislature can enact a rule enact a law to invalidate those rules. I believe there's also another option where each year all the rules essentially expire unless the legislature approves them. So then the legislature could pull out the rules, any rules that they have issue with, and then any other rules that were not pulled out would be re-upped every year by the legislature. So there's a couple approaches that I noted, but as far as the states that do require that legislative approval, I'm not aware of what happens if those rules are not approved.
And one more quick question, Mr. Chairman. Have any of those laws been upheld by a court? You mentioned that a few states have said that this violates separation of powers. I'm just curious whether any of those laws have been found to be respectful of separation of powers in those states, or whether they just haven't been challenged and seen a court decision yet.
Mr. Anderson?
Mr. Chairman, I'm not aware of that. I have to go back and look at these most recent ones to see if I'm not aware if they've been challenged or not, these RAIN-style approval, and I can certainly come back with some information for the committee on that.
Thank you.
And that's where my question kind of lies, is it's a checks and balances, and it seems like it's in reverse, because you come up with the law and rules follow it to implement that with the intent of the law in place. And so I would imagine that Management Council would ratify it before those rules go into effect, because otherwise you're adding, in essence, amendments to law that have not been ratified by the legislature that wrote it. And that's just how I see it. It's kind of a backwards approval situation. So what would you comment to that?
Yeah, Mr. Chairman, so yeah, like I noted, some courts have said, that once once the legislature has validly delegated its authority and the agency has rulemaking authority, that then it's kind of an executive branch function and then becomes a separation of powers question. That's not a universal decision, I don't think, among courts. There are others that have allowed these types of veto provisions to meet their separation of powers requirements. So again, I think it is just an interesting question, and one I can certainly provide a little more information to the committee on.
Senator Rothfuss?
Thanks, Mr. Chairman. That brings up a good point. I'm curious, Mr. Anderson, whether you've seen any circumstances where, and I don't even know how this could necessarily be done, but you've got a rule that's in place that some members of the legislature feel are violating statute, which is generally the concern with the rules. Is it basically required that you have some third party file a lawsuit to get that interpretation in front of the court? I don't necessarily see a path where a legislature could appeal to the court for consideration and judgment on whether a rule complies with or fails to comply with the statute itself as a remedy. And I doubt any state has done that, but it seems like it's a struggle for separation of powers at that point. But anything along those lines that you've seen where the courts become the independent arbiter?
Mr. Anderson?
Mr. Chairman, and not that I'm aware, for the most part, what I've seen, and similar to Wyoming, is the legislature and an individual legislator's ability would be to introduce legislation to clarify or limit that rulemaking authority or to invalidate the rule, and then that would pass through a normal bill-making process and would go to the governor for veto and all the normal rulemaking stuff, or lawmaking provisions. Of course, there is the ability to have judicial review of rules, but that would likely be someone who's affected by the rule and not a legislator.
Senator Ide?
Thank you, Mr. Chairman. I'm a little bit confused back to the emergency rules, and you've got this stricken on page 2 here at the bottom. I'm a little bit confused on that. The way I understood the testimony earlier was that it was necessary to have the emergency rules for time constraints and those sorts of things. Can you explain that a little more, Josh? Thank you.
Sure thing.
Mr. Anderson?
Mr. Chairman, yes. So all that is removing emergency rules from the definition of major rules. So as Mr. Petrie noted earlier, a lot of times what's happening is the agency is going through the rulemaking process. They're not going to have their rules done in time for July 1st or whatever the deadline is. And so they do emergency rules that are identical. And as Senate File 127 was enacted, essentially both of those rules would need to go through the major rule analysis. but they're going to be essentially identical. And by the time that analysis is done, the 120-day emergency rule period is likely expired. And so what this would do is just take those emergency rules out of that definition of major rules so that we wouldn't have to be doing this analysis on those rules, only on the rules that are going to become the permanent rules.
Representative Lean?
Thank you, Mr. Chairman. Just to follow up on that, you said that that usually the emergency rules are identical to the rules that we're looking to put into place. We had a comment earlier from a senator about what happens if there are no rules. They could just function. Is it true that they could just function without that emergency rule process as if the rules that they are proposing is their bottom line until that is ratified?
Mr. Anderson?
Again, Mr. Chairman, like I said, I would think it would depend on the program. I mean, I don't know how they may or may not be able to function without rules in place. So, as was noted earlier, the law is still the law, but a lot of times it's unclear how to apply that without further rulemaking. And so generally the process is the agency will adopt emergency rules just for the brief time while they're going through that formal rulemaking process. And then when the formal rules are adopted as final rules, then the emergency rules expire. So they're intended to be just temporary. They're in current law just limited to a total of 240 days.
Follow up?
Thank you, Mr. Chairman. I guess another way to phrase this is, if the intent is for them to be temporary, could we also function on the intent of the permanent rule?
Mr. Anderson?
I mean, I guess so, Mr. Chairman. I mean, I think that's essentially how it works now. It's just a little more formalized. That's essentially two copies of the same rule. One is just designated as emergency rules, and then everyone knows they can go and look and find those rules for that brief time that they're effective. And then when the formal rules are adopted, they go away. But it's essentially the same, usually the same rule. Sometimes they do change as they go through the rulemaking process and they get comments and so forth. But and largely they stay the same from the emergency rules to the final rules.
So, Mr. Anderson, as a matter of solution in legislation, could you have it to where once a bill is through, you've got your enacting clause, could there be a period of time before that enacting clause takes place where rulemaking would happen and be approved by either management council and/or the governor?
Yeah, Mr. Chairman, I think that is one of the options in that, and one of those staff comments to that one of the options may be to kind of reconsider how we do our normal effective dates and maybe extend those out to give additional time if you wanted to have some legislative approval of the rules, as we only meet once a year. To give some time for that rulemaking to happen in time for the legislature to formally adopt those.
Okay. As a matter of questions, then, let's kind of go through this one recommendation at a time. So we have first the definition of a major rule. Does anybody on the committee have a question on the consideration of deleting designated by management council language from the definition of major rule? Are there any questions? Which should be on page 2 of the fact sheet for SF 127 amendment options.
And Mr. Chairman, you can see that on page 3, line 19 of the bill as well.
Off the bill instead. Would the committee rather work off the bill? Okay, let's do that then. Yes, Representative Lee.
Thank you, Mr. Chairman. I have a question about exempting ourselves from the federal rules. If we are to exempt all federal rulemaking from this process of review for state policy, are we then subceding our sovereignty to the federal government?
Mr. Chairman, that's a good question. I think you could exempt it from the major rule review process. It still wouldn't mean that the legislature couldn't come in and adjust that rulemaking authority or invalidate the rules after the fact if they found that it was violating some policy of the state. But I think why some other states have exempted rules required by federal law are just because a lot of times that it's contingent on, or it's to allow for the receipt of funds or for other reasons, it may already be authorized in statute. And so it may just be an unnecessary additional step when it's likely to be approved anyway. Again, we do a lot of rules, and they wouldn't be necessarily major rules, but we have all the substances designated as Controlled Substances Act by the federal government. And so those always just come through as rules. We have to have our Controlled Substances Act match the federal government one. And so those rules just come very consistently throughout the year as one example. So I think there's just some of these potentially routine rules that come from the federal government that you may or may not want to have go through the major rule process.
Follow up. Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Can you give an example of a federal rule that would come through the state, through the governor's office, where it's not routine? Or what you would consider routine?
Mr. Anderson?
Trying to think, Mr. Chairman, and a lot of times as these rules come through, there's a portion that's following state law and another portion that is to comply with federal law, so sometimes they're intertwined. I'd have to probably go back and look and see if I can find some examples from the committee for what may be some major rule or some rules in response to federal action that you could take a look at.
An emergency rule, would that doesn't include, say, something that's in another statute, like a health emergency?
I don't think so, Mr. Chairman. I'm trying to think. We may have done some rules during COVID that were only effective essentially for 120 days that may or may not have had accompanying permanent rules go with them. Again, I'd have to go back and look at that. We did a large volume of rules back during the COVID era, and I'd have to go back and look and see if there are examples of those that were just emergency rules and not ever permanent rules.
Okay, that may be one thing to look at. Any other questions? Representative Lean.
Thank you, Mr. Chairman. Mr. Anderson, could you tell me something like the Rock Springs BLM rules that came down? Would the state have had quicker recourse on that or more help to that local community had there been a rule promulgated through a committee first?
Mr. Anderson?
And Mr. Chairman, I'm trying to remember were those just federal rules or were those, I think if they're the BLM rules, they're just through the federal agency and the state. We would not have taken action on those as a legislature. They're coming through the federal process.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Mr. Anderson, when it comes to the state adopting codes or international codes or rules, such as in 2024, why the state adopted the International Fire Code, the International Building Code, the International Fuel and Gas Code, Mechanical Code, and Existing Building Code. None of that went through the legislature. Would that be considered non-routine?
Mr. Anderson?
Mr. Chairman, I think those would be, we do have a process in the Administrative Procedure Act for adopting things by reference. And so that, I think that would have been done through that process. So likely was noted in the, or reviewed through the normal rulemaking processes.
Any other questions? Yes, Vice Chairman Larson.
Yes, Mr. Chairman, thank you. In your write-up, you've talked about agencies are required to consult and solicit information from businesses and such in the Kansas and Oklahoma, Wisconsin language, in the Raines law. Where could we put that in this bill? Is that in the proposal?
Mr. Anderson?
And that's a good question, Mr. Chairman, and that was out of Mr. Petrie's, some of his information. So I'd have to do a little looking in that, but it's certainly something we could find the spot to add it, Mr. Chairman, if that's the direction of the committee.
Follow up? Okay. Any other questions? Yes, Senator,
Just real quick, thank you, Mr. Chairman. Representative Rodriguez brought up the question on adopting international code, fire, building, what have you. I guess I don't quite understand the process. If the state does adopt those international codes, do the counties therefore, does the state have primacy on that? So if a county doesn't decide to institute those international codes, do they have that ability? Thank you, Mr. Chairman.
Mr. Anderson?
Mr. Chairman, good question, Senator Ida. I think it would depend on the context, and again, I'd have to look more specifically at each code and in what context it was adopted by reference. So, certainly, if there's a specific question, I'd be happy to look into it for you.
Any other questions? Any other questions on any other aspect of the bill, suggestions for change? Representative Lean.
Thank you, Mr. Chairman. Mr. Anderson, forgive me, I've slept since session, but could you walk me back through the enforcement mechanisms that were in Senate File 127 that gave us the opportunity to make sure that when a rule was promulgated by an agency, that they weren't continuously under the specific dollar amount so that they would not necessarily end up in front of a committee?
Mr. Anderson?
Mr. Chairman, I apologize. I'm not sure I'm totally following the question, Representative Lee.
Can you rephrase the question?
Is there an enforcement mechanism within the Raines Act to identify that the rules come through the committee before being promulgated?
Mr. Chairman, I don't believe so. So Senate File 127, as it was enacted, it would have required the Legislative Service Office to review any rules designated as major rules, provide that analysis to each member of the legislature, and then it would be up to the legislator individually to bring a bill to invalidate that rule.
So I think moving this along, since we have this as a working draft to look at today, we'll kind of look at that next meeting, but I'd like to see if there's anybody else in the audience that has
Sure. Good morning, Chairman. My name is Ross Schriftman. I'm a citizen living in Casper. From 1977 to 1984, I was a field auditor for the Auditor General's Department of Pennsylvania, Department of Bureau of State-Owned Institutions. We did financial and compliance audits on state hospitals, prisons, and colleges. 1979, I was a candidate for county controller, Montgomery County, Pennsylvania. County of outside Philadelphia has about 800,000 people now. Want to comment on these RAINS Acts? There is an inherent tension between the branches of government, which is a good thing, and appreciate the discussion this morning. One of the concerns that I have is when legislation is enacted, it has to be as clear as possible to regulators of the departments, the bureaus, of what the intent is. So I'm very much in favor of findings in legislation. It shouldn't be overly descriptive to prevent the agencies from complying. I do want to mention two things on the federal level that are of concern. One was a Supreme Court decision many years ago now, the Chevron deference, which said that if legislation is not clear, then they defer to the agencies to make their determinations. Recently, the Supreme Court has kind of moved in a different direction, giving Congress more authority on that. Some of the legislation that's been passed in the last, in 2010, was the Affordable Care Act, or the Patients Protection and Affordable Care Act. It's about 1,800 pages long, and if you read through some of that, it defers to the Secretary of Health and Human Services to do basically everything that the legislature says you have the ability to create this and that, and it's overburdened, and that's been a problem as well. Congress kind of, in my view, didn't do their job properly. I think following the legislature here, I think most legislators have done very, very well in defining legislation. Interestingly, there was a situation that probably is the most egregious bureaucratic overreach in my lifetime. And I'm an insurance agent. I do long-term care, Medicare, I help seniors. There was legislation in 1997. It was called, I don't have the name of it, but it dealt with reverse mortgages and long-term care insurance. Congressman Rick Lazio of New York in 1997 proposed a bill. And if you're familiar with reverse mortgages, they're used for elderly people who are house rich but cash poor. My mother, actually, I helped her get a reverse mortgage, and she was able to stay at home. And between her long-term care insurance and repairs we made to the house, we had a live-in companion in one of the bedrooms that lived with us. So Rick Lazio's bill would have required that if somebody had a long-term care insurance policy, that the federal government would waive the 2% origination fee. So for instance, if somebody took out a reverse mortgage of $100,000, they wouldn't have to pay the $2,000 origination fee from the, it's a authorized federal health, Federal Housing Authority program, if they had long-term care insurance. The bill was bipartisanly supported, signed by President Bill Clinton in 1997. The Health and Human Services, the Housing and Urban Development opposed the bill. they said that many things that they didn't like about it. They kind of were very paternalistic that, oh, the seniors would be, would be abused by the bill. They also, some of the lobbyists that were opposed to it said that somebody would buy a long-term care insurance policy in order to get the 2% origination off. And then what would happen is they would drop the insurance policy. But the insurance policies for somebody that's 70 years old is like $4,000 or $5,000 a year. Why would somebody pay $4,000 or $5,000 a year to eliminate a $2,000 expense? The bill was signed by the President of the United States, the only elected official of the federal government. Do you know when that regulation was finally approved? Never. It is a piece of federal legislation on the books, and the president had the authority to overrule the regulators. I don't know why it didn't happen, but we have to be careful with this. Again, there's a tension between the executive, the governor of Wyoming, and the legislature in determining this. But again, I would be in favor of any kind of legislation that defines what the intent of the law is. And I am very much in favor of this legislation. The amendments look pretty good. I would be in favor of the LSO making that determination of the economic cost rather than the agency, because the agency obviously would want less oversight of the decision-making of whether there's the economic threshold or not. And again, I thank you for your time. Any questions?
Thank you. Questions from the committee? All right, thank you very
Thank
much
you.
for testifying.
Sure.
Welcome. Please state your name and what
My
comments that
name
you have.
is Kevin Lewis. I live in Laramie County. Mr. Chairman, Senator Rothfuss, there is a case in Wyoming Supreme Court. I don't remember the case number, but it went by the initials MK versus Peter Froelicher, District Court Judge. The case was about MK, who's a juvenile, wanted to change her sex on her birth certificate. And the LexisNexis books kind of allude to the fact that Mr. Froelicher probably did allow her to change the sex, but the Attorney General Couts wrote a separate opinion concurring with the majority, saying that the intent of the legislature would probably be violated by that. And so there is some conflict on that, and he would be an expert to talk to.
Any other questions? Thank you very much. Any other member of the public that wanted to speak on this? Is there anybody online? No? Okay. I recommended we digest this for next meeting, but what is the pleasure of the committee? Is that all right? Okay. Oh, Representative Lean? Okay. All right. Let's take a 10-minute break before moving on, and we'll get to the evaluation of executive branch agencies. Okay, we'll come back into session. Tanner, we're back online? Okay. We're going to backtrack a little bit. We did have a few more questions from the committee for LSO, so we'll go back to the bill and anybody that has any questions. Representative Locke.
Thank you, Mr. Chairman, and really, I'm sorry, I'm just asking for maybe a deeper conversation on the change to the bill related to removing the emergency rule portion, that strikeout on page 3, line 18 and 19. Honestly, I'd just like to have a conversation. I want to understand better the consequences of this strikeout and the impacts, the pros and cons. I'd like to hear others discuss it as well. And so just so I can have a better feel for, what the true impact is and understand it better. Thank you.
Either one of you want to take that?
So Mr. Chairman, I think some of the discussion at the last meeting was essentially, in most cases, I think it would be, I guess, two issues. Number one, kind of a duplication of effort in that most of these emergency rules are also being done as permanent rules. And so if we are doing an analysis of both of them, there's some duplication of effort there, especially if they change maybe just slightly. And then I think the second part of that is that due to the length of time of emergency rules can be effective versus the length of time of this analysis, there would not be very much time to respond to them before they would expire. So even if you wanted to see an analysis of it, there may be limited utility of that because the rules would likely expire shortly after the legislature saw the analysis. So that was kind of some of the discussion. I don't know if Mr. Petrie had anything to add on that.
Mr. Petrie?
Mr. Chairman, I would agree with that. You may recall at the meeting that we had in May, there was a one-page timeline that kind of set out the rules promulgation process in the left-hand column on the side of the page. And then in the middle of the page, there was another column that showed the promulgation process after passage of Senate File 127. And so that was largely the point to that timeline, if you will, is what Mr. Anderson just said, that we would, by including emergency rules as being subject to review in terms of whether they are or they are not a major rule, you would have to do that. You would potentially be doing that analysis 3 times for the same set of rules. You would do it for the emergency rules, which again, at the onset, are a mirror image of the regular rules that take longer. Then if you had an extension of those emergency rules, which is often the case, you would have to do that analysis again. They would still look the same as the regular rules. And then, of course, you would have to do it for the regular rules. So as Mr. Anderson indicated, it's a bit redundant, I think, to do it on those emergency rules. But also, as he indicated, the timing, the regulatory impact analysis on emergency rules would barely be finished by the time that those emergency rules were replaced with regular rules.
Follow up?
Thank you, Mr. Chairman. And I guess that I'm going to ask a question, just this question, but if we go in the direction of having these rules, having this information provided by the agency, then I would argue that this is a slightly different conversation, is what I would say. And so I want to throw that out that says, hey, even for emergency rules, I think if we're going to push this back on the agency, I think even for emergency rules, that information needs to be in hand for the people who are making these decisions on even putting an emergency rule in place in the absence of that, at least that information. That's me thinking out loud, and I'm just throwing that out as more of a conversation than anything. Thank you.
Senator McEwen.
Thank you, Mr. Chairman. I'm not necessarily the sharpest tool in the shed. So as I look at this, Can you tell me what this does or what it changes from how we do business now? I mean, there's some nuances, but it seems like business as usual. And I'd just kind of like you to break down what's different. Thank you, Mr. Chairman.
Mr. Anderson?
So, Mr. Chairman, and just to clarify, you're talking about what Senate File 127 compared to the current, or what this does to Senate File 127, Mr. Chairman?
Senator McEwen?
Both. To me, well, I'll wait for an answer. Thank you.
Yes, sir, Mr. Chairman. So I guess Senate File 127 in general creates, so currently we do a review of rules based on whether we think they meet the statutory rulemaking authority and so forth, and meet the intent of the legislature. That process goes, we do the review, it goes to Management Council makes a recommendation to the governor, and then the governor either approves the rules or not based on that review. Senate File 127 added a parallel review process to look at fiscal impacts caused by those rules. And it follows a little different timeline, as Mr. Petrie noted, and also it doesn't go specifically to Management Council, but to each member of the legislature. Then could take that information and decide if they wanted to bring a bill to invalidate those rules or not. This bill changes that major rule review process only fairly slightly. First, it would require agencies to provide that information at the beginning of the process. As Senate File 127 was passed last year, it would be up to the LSO and Management Council to determine what is or is not an administrative rule subject to, or a major rule subject to this additional analysis. This would first put that impetus on the agency to specify whether or not they believe it's a major rule that would be subject to the analysis. Then it also changes, as was just discussed, that definition of what is a major rule by removing emergency rules, and also by removing the designation of Management Council. And then finally, it just changes that dollar amount from $1 million to $200,000 per year. So I hope that helps clarify, Mr. Chairman.
Thank you, Mr. Chairman. Don't I, as a legislator, already have the ability to bring a bill to change the rules? Thank you, Mr. Chairman.
Mr. Anderson?
Yes, Mr. Chairman, you do.
Follow up? Did you want to answer that sharpest tool in the shed question? No. Representative Locke? Okay, you go.
Thank you, Mr. Chairman, and thanks again for your explanation. But let me ask another question along the same lines of the ones I asked before, but let me ask this question. In removing, so we have these changes that require certain information to be provided to the LSO as part of this analysis. So by removing it, by striking it from the paragraph, and I'm talking page 3, lines 18 and 19, that strike out there. By removing that, do we change the agency's requirement for providing that data? Thank you.
Mr. Anderson?
Mr. Chairman, I do not believe so, unless there was an instance where an agency had just done an emergency rule for a limited time. But I can't, like I said earlier, I don't know if I can think of an example of that. So in every other case, that information would still be provided through the normal rulemaking process. It wouldn't be duplicated with the emergency rules.
Thank you, Mr. Chairman. So just for clarification, sorry, I'm a little thick here. I'm trying to make sure I understand. So even for a rule that was an emergency rule, they would still be required to provide that additional data based on the changes in 16. Is that accurate, or am I inaccurate with that?
Mr. Chairman, if it was just the emergency rule, they would not provide the additional information because it's only for rules that meet the definition of major rule, and those would not include emergency rules. So they would not provide it then, but they would provide that information when they went through the normal rulemaking process.
Vice Chairman Larson.
Yes, Mr. Chairman, thank you. I'm going to go back to, I think it's page 2, and maybe discuss a little bit about the consult and solicit information. And I think that's maybe where it could be inserted to require the agencies to reach out to what was suggested in the fact sheet. So I would ask that that be put in there somewhere.
Mr. Anderson, is that all right?
Okay, Mr. Chairman, I think I'm following along, Mr. Chairman. I think that would make sense.
Okay.
Okay. Any other questions? Mr. Petrie, did you have additional comments that you wanted to make as well?
Mr. Chairman, one thing that I at least prepared for in the conversation today was, this came up during the meeting in May in Lander, was staffing. So as it stands right now, the appropriation is $400,000 per year to additional employees to staff this regulatory impact analysis. And so the discussion at the meeting in Lander was to drop that threshold. That threshold in the introduced bill was $100,000. So through amendments, that threshold.
Was that I'm sorry, was that a million, right?
It was $1 million,
Okay.
yes. And that's where it stands today. In the bill draft that Mr. Anderson has prepared, that threshold would drop to $200,000. That was, again, discussion that we had a couple of months ago. So that's where the proposal stands today. So the question arose was, well, depending on what the threshold is, what are the staffing needs? We took a stab at that. Again, we tried to determine the workload that we would see, the number of rules that would satisfy the definition of a major rule, and so the number of rules that we would have to do these analyses on. We did that by looking at all of the rules that were promulgated through the Secretary of State's office for 2 years. But again, there wasn't enough information with most of those rules to say, yeah, this one's either over $200,000 or it's over $1 million, and so that effort wasn't incredibly helpful. So what we did then was, we of course looked at, and I deferred to this, or I referred to this earlier, was staffing for those states that have a little bit more experience in this area, that have implemented laws like this in the past. Again, state of Florida, the staffing for these types of analyses, less than 1% of their entire staff, but it's 11 people. Kansas, about 5% of their entire staff, 8 people. The history for the staffing appropriation, not necessarily the funding appropriation of $400,000 with the 2 employees that are appropriated, has not changed since the introduction of the bill. I know that when the bill was being drafted, LSO's recommendation was 3 additional staffers. And that was when, and then the bill came out as introduced as a $100,000 threshold. Staffing was at 2. So LSO recommended 3 during the drafting process. The introduced bill had 2 additional employees. Even when the threshold increased from $100,000 to $1 million, that staffing stayed at 2 employees. And then with this proposal, that threshold dropped from $1 million to $200,000, the appropriation for staffing is still 2 employees. So I just think I wanted to give some history on that, as well as our attempts to try to determine what would be the right number of staff. If if we use a $200,000 threshold and it were not to go higher, and I know there was some discussion about that in the last meeting as well, but if we stuck with that $200,000 threshold, we would be using a threshold that was similar to both Florida and Kansas. Given that Kansas is relatively new to this game, as we would be, certainly not as experienced as Florida is in implementing an initiative like this, I relied a little bit more heavily on Kansas's staffing. If I apply those same types of expectations to LSO here in Wyoming, as they have admitted to or they have bought into in Kansas, it comes in somewhere between 2 and 3 full-time equivalent employees. So my recommendation would be 3, but certainly I think that if we use Kansas as a guide for what would be necessary, because that's probably the state that we would look the closest to in terms of, or we would look the closest to in terms of implementation of the program, it would probably be Kansas. So we would fall somewhere between 2 and 3. But more than anything else, I just wanted to bring that discussion because obviously the number of analyses will be driven to some degree by whatever that threshold is set at. If you set the threshold low, you potentially need a greater number of staff. If you set the threshold high, you potentially need fewer staff because you're just not going to have as many rules that clear that bar for analysis. But at the $200,000, again, I used Kansas as an example, and if I just look at it proportionally, the staffing level comes in between 2 and 3 full-time equivalent employees.
And just as a follow-up to that are those flex positions, would they do more than just that analysis?
Mr. Chairman, yes, they would. They would be a part of the research and evaluation division. And so certainly the reason for those positions to be added would be for these regulatory impact analyses. But as we see with other work in the research and evaluation division, it can fluctuate on an annual basis during this session, of course. We're the division that staffs all the committee meetings, and so everybody's incredibly busy then. Once you get past the session and you're in the interim period, it's largely driven by research, like you see here today, in support of committees, as well as confidential research for individual legislators. But there's no predicting how that will arrive or what the volume will be on a regular basis. I think when we're talking about rules promulgation, what you'll see is that there will also be peaks and valleys. Again, most new legislation has an effective date of July 1st, and so you're going to see a peak that coincides with the effective date of new legislation, that July 1st. But there will also be times throughout the year when agencies want to amend their existing rules, and that won't necessarily be tied to a July 1st date. So there will be some fluctuation in the need, but as we do with the other divisions at LSO, we all support each other, and when resources are needed, there's flexibility between the divisions themselves.
All right. Thank you.
You bet.
Oh, Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Mr. Petrie, in your research, you stated the number of times that these joint committees met in these different states that you referenced. I'm just curious, did they meet during session as well? I know we have a window of priority time before law is enacted, but were they active during session?
Mr. Petrie.
Mr. Chairman, Representative Rodriguez-Williams, I don't have a solid answer for that. I would assume that committee certainly could meet during a regular session. If I remember correctly, Florida has a 60-day session, and it runs start to finish, similar to Wyoming's 20-day session and 40-day session. And I think that you could certainly have a situation where an agency is attempting to promulgate rules and just the timing of when they start that process would essentially include a regular session. And so I don't think that there's anything that would preclude a committee like that from meeting during an established regular session or a budget session.
Follow up? Okay, any other questions? All right. We're almost on schedule. We'll move on, Mr. Petrie, to the evaluation of executive branch agency programs. You have research documents.
Yes, thank you, Mr. Chairman. Relatively lengthy document here in your packet, but most of it is examples of what we found in our research. So interim topic number 2 really was to take a look at potentially repealing statutory authority for programs that are no longer being operated or are no longer being funded. And so essentially cleaning up the books, if you will. What we did was we took an approach to see what has been done in the past along these lines. And really that's what you have in this research memo. So at the beginning of the process, what we did was we asked ourselves 4 questions. What are agencies' programmatic priorities for the 2025-26 biennium? And I'll touch on every one of these questions in a little bit more detail as we work through this. What is the major new programs and major modifications to existing programs report? What is the delayed effective dates and repeals report? And what is the regulatory reduction task force? These are all things that are in place now or have been in place in the past that have some similarity to what we're considering here today, which is keeping track of programs that may be temporary in nature or maybe sunsetting or simply may no longer being operated or being funded by the legislature, and identifying those for removal. So again, as with my previous presentation, I'm not going to go through this document line by line. I'll just touch on some of the things that I think are most relevant. And then perhaps make some comments on what I see as the relative value of some of these different ways of looking at this. At the top of page 2 in that first full paragraph, there's a statement there that says the priorities for each agency are shown in section 5 of each agency's individual budget request. For an example of agency biennium priorities, see figure 1. And for a fact sheet summarizing each agency's priorities for the 25-26 biennium, see Appendix A. Just shortly after our meeting in Lander back in May, Chairman Knapp, Vice Chairman Larson had a document that we had prepared preliminarily that shows this table 5 for every single agency. They felt like it was good information, and so they asked us to share that with all of you. We did that. It's probably been about a month now. It would be hard to forget that document because I think it was 87 pages long. But basically what it did was this figure that you see here on page 2 of your handout is, for those of you that are familiar with biennial budgets, every single agency has to include this in their biennial budget request. Relatively close to the front of their document, whichever agency it may be. But basically what it is it is a table where every agency takes every one of their programs and prioritizes them from obviously the one on top, priority number 1 here for the Department of Revenue Administrative Services, collection and distribution of taxes. That is their highest priority among their programs, all the way through priority number 9, which is the property tax refund program. So what this table does is I think it gives you an idea of how the agencies themselves see their own priorities in terms of operating programs. I want to, I guess, suggest a little bit of caution in using this because typically agencies, this is a difficult exercise for agencies to go through. I know this for a fact because I did it myself for 17 years. Typically agencies are going to lean toward high priorities for their programs that have the greatest amount of funding and, quite frankly, the greatest amount of staffing, because those are indicators of need in the state. And we included the Department of Revenue as an example as well, because priority number 9, property tax refund program, you can see there that it's not funded for 2025-26. But we want to be careful, because that is a program that stays on the books, and then the legislature determines on a biennial basis whether they want to fund that program or not. So we would want to exercise some caution in using something like this, which is a fairly high-level document, to say, well, we're not funding the property tax refund program, let's consider eliminating it. It's still on the books, it's still available for the legislature to fund. So I think using that 87-page document to see what agencies' priorities are is of some value, but I don't know that it's of a great deal of value in attempting to identify programs that can be, where their statutory authority can be repealed. But one of the tools in the toolbox, per se. The other thing that agencies must do, again, in their biennial budget request, is they need to essentially tell the legislature where they derive their statutory authority from, why they exist, why their programs exist. And so every agency has to do that. We've given you an example of that. At the bottom of page 2, it's just the Department of Revenue, again, their statutory authority to operate and the statutory authority for their programs. This too, I think, could be used as a way to compare their statutory authority to their programmatic priorities that you see in that table. But it's a pretty rough comparison, because their statutory authority is typically going to be relatively broad, whereas their programmatic authority and the programs that they operate are going to be a little more granular in nature, a little more detailed. And you could have multiple programs that would stem from one statute. And so it's not a one-to-one match. It's not like you can create a matrix that says, here's the statute, here's the programs that align with that statute perfectly. But that is something that we could potentially do. Again, I think that it's probably of somewhat limited use, just because we don't have a really nice cross-reference between statute and the way that the agencies structure their programs under those statutes.
Vice Chairman Larson, you have a question?
Yes, Mr. Chairman, on your presentation here, page 1, being on the JAC, and just, I think, good information for all of us, where it describes the budget process begins with the budget department preparing a standard budget request for each agency, submitting the standard budget to the agency in July. And then it says the standard budget is roughly equivalent to what the agency had received for the prior biennium. Is there an automatic percentage that's added to that standard budget? I kind of thought there was. Is there a 3% that's added quite often?
Mr. Chairman,
do you know?
Vice Chairman Larson, no, there is not. You'll hear the term ECA, or external cost adjustments. Those are typically the only way that state appropriations can be increased automatically or across the board. You can have statutes that, for programs that require inflationary increases, but typically even those are at the discretion of the legislature. I can give you an example. At the Department of Health, there is a program, it's called EIEP, Early Intervention Education Program. It serves children with developmental delays prior to their entry into the kindergarten K-12 system. And there's a statutory mandate that every year they bring a request for an external cost adjustment to address their inflationary increases in their costs. But the legislature has the authority to fund that or not fund that, or even fund it partially. And so the short answer to your question is no, no automatic inflationary increases. If we jump to page 3, you'll see the title at the top of that page, Major New Programs and Major Modifications to Existing Programs Report. This was a report that existed for 20 years, from 1997 to 2017. And it was required by statute. It required LSO to present an annual report to this committee listing the new acts that created major programs or major modifications to existing programs. And if you jump to the back of your handout, it's Appendix B will give you an example of what that report looked like. I think we only included the first 3 pages of that report, which that specific year, which was the last year this report was done. It was a 12-page report. We gave you the first 3 just so you could get a flavor for it. The way that this worked was the Legislative Service Office would generate this report. They would provide a preliminary report of these new acts to the chairman of each house and Senate Standing Committee to allow them to comment on those major new programs and major modifications to existing programs. Then that report, along with those Standing Committee chairman's comments, would be provided, would be incorporated into the report and given to the Management Council. The statute mandating that LSO prepare this report was repealed in 2018. I don't know the exact reason for the repeal of that report, whether it felt like, whether the general feeling was there wasn't value in that report. But I know that at that time in state government, there was also a push to reduce the number of reports generated, not only by LSO, but there was also a push by Governor Meade to reduce regulations and rules, quite frankly. Again, this one, at least right now, has no use whatsoever because it hasn't been generated in 8 years. Something that could probably be generated again, but it would probably require revisiting that statute that was repealed in 2018. But I think, at least in terms of identifying programs that might be ripe for repeal of their statutory authority, this really just gives you a way to check those programs that have been added and whether the intent was for those programs to be permanent or perhaps maybe temporary. It gives you a way to check up on them. Okay, let's jump to the next one, delayed effective dates and repeals report. This one is still generated. LSO annually prepares a report listing laws that will become effective or will be repealed on a future date, titled the Delayed Effective Date and Repeals Report. If you go to the back of your document, again, you'll find an example of this in Appendix C. I think we included the entire report this time because it was only 3 or 4 pages. But this report is still being used. Just one other comment on this, and it's toward the end of that paragraph. Some provisions provided in the listed legislation reflect dates allowing the legislature to review the status of the law in the future. So this report will tell you if a law has been passed for a new program, but there's a sunset date associated with that program. And so again, it's a way to ensure that programs that maybe were intended to be temporary in nature, that in fact, they were temporary in nature, and that if that statutory authority needs to be repealed, it could be. Typically, the statute for a temporary program will specifically state that sunset date. But again, just another tool that we might have to identify some programs that could potentially have their statutory authority repealed because they're no longer being operated or funded. Again, I think that this is a useful tool as a reminder, but I would also say that the budget division of the executive branch tracks these things very, very closely because of the funding. They know when a program is going to sunset and when the funding for that program will cease. They know if there's a delayed effective date for a new program, and so the appropriation for that program won't kick in until that effective date. So I think that, again, while this is a useful report, certainly, to give you an idea of delayed implementation dates and repeal dates, sunset dates, I think that for the most part, the executive branch through the budget division tracks this very, very closely. Our next tool, if you will, that we could use is, there's an example of a regulatory reduction task force. You'll find that example, a couple of things associated with that in Appendix D to this document. There was a regulatory reduction task force created by the Management Council in 2023, and it was specifically to look at rules, regulations, statutes, and processes affecting the mining, agricultural, and construction industries. And this is a way, if there are industries, if there are agencies, if there are programs that the legislature or the Management Council wants to look at in great detail, I think this is a good example of that. I know that with this regulatory reduction task force, ultimately the Department of Agriculture or agricultural activities were exempted. They were taken out of that study, if you will, but the study continued for the mining industries and the construction industries. And I think it was a very useful effort, and I think that the agencies were very receptive to it because it allowed them to also identify things that they felt could be improved in the areas being studied. So I think it was a very collaborative, very cooperative type of effort. But obviously, it's a fairly intense thing. You're looking at very targeted areas. There's a lot of work that goes into it. But I think that there's a lot of useful information that comes out of it. So again, useful, but very high effort in targeted areas, but it's not a cursory review, which is probably what we're talking about with interim topic number 2 in terms of trying to identify statutory authority that can be repealed. The last thing, and we touched on this briefly at our meeting in Lander in May, was a survey of agencies. We had understood that there was a survey of agencies that was done in 2012 or 2013, so we looked for that, but we didn't find it. So we could create this very easily if we wanted to. And again, I think that agencies would be fairly receptive to it because it would give them an opportunity to kind of clean up the books as well for statutory authority that they have for programs that may no longer be funded or operated, but they still have to report that statutory authority in the budget process. There was a committee, the Select Committee on Archaic Laws, that existed 2009 through 2016. And so we pulled all the hard copy records from state archives to see if we could find a copy of that survey that was used to ping agencies and ask them about this. We just didn't find it. But again, I think that that might be a useful effort, and I think for the most part, it would probably, although it would create work for agencies, it could also enable them to kind of clean up some things that are still on the books affecting their agency. So that's something that we could certainly pursue. Would certainly want the governor's office to be aware of it because we would be impacting to some degree the executive branch agencies with a request of this nature. But that is a summary of what we found in terms of historical efforts to look for things where statutory authority could be repealed for programs that aren't being operated or funded, kind of the evolution of it, the relative value of the different types of things that have been looked at in the past, and then what we could potentially consider in the future. With that, I'll stand for questions.
Questions from the committee? Representative Lean.
Thank you, Mr. Chairman. Thank you for this research. I appreciate it. My question is, you said that it's statutorily that they have to continue to report on those even though there's no funding currently going into them. Therefore, would it be easy to say that in a short amount of time, we could identify the programs that are not being used?
Well,
Mr. Petrie.
Mr. Chairman, Representative Lean, when I say that statutorily they have to report on it, there's no detailed reporting per se. So, and on page 2 of your handout at the very bottom, what I was referring to is that An agency will still have to report their statutory authority for everything, again, that they have authority for. That could include programs that are no longer funded by the legislature or that are no longer being operated. So in some cases, it's going to be overkill. What they report as their statutory authority may actually include statutory authority for programs no longer being run.
Follow up? Any other questions? Okay, thank you. As usual, excellent job.
Thank you, Mr. Chairman.
Okay, next up, we will have Department of Audit. There's the Director and Administrator. If you guys could introduce yourselves, please.
Good morning, Mr. Chairman, members of the committee. Justin Chavis, Director of the Department of Audit. I have with me Rich Cummings, Administrator for the Public Funds Division of the department. We provided some information regarding audits of government entities that was requested in the previous meeting, and so we're just here to answer any questions the committee may have regarding audits.
Okay, questions from the committee? Representative Lean.
Thank you, Mr. Chairman. Thank you for joining us today. Thank you. My question for you is in regards to the non-compliance reports that we're receiving. I specifically want to ask you about one for Bear River. There's a memo from July 15th of 24 where the Department of Audit has said that 11 of 14 findings are still not resolved. And I was curious to know if you've had any follow-up in the last year with Bear River.
Director.
Mr. Chairman, Representative Lean, I might have to defer to Rich on if we've had any. My guess would be not beyond issuing the follow-up report to the town and the governing body.
Mr. Chairman, Representative Lean, no, there hasn't been any follow-up beyond that. That was our follow-up of the previous audit that we've done and everything. We tend to give them their reports or publish that report to let them know where they sit in regards to how our audit are. So the way we do it, just let me start from fresh. So basically the way we do it is we'll go out, we'll do an audit of an entity, and then we'll give them a few years to try and see if they can correct the issues that we've identified. And in this particular case, that's what you're looking at now is that follow-up audit, at which point we'll give them time and we may follow up on it, or we'll probably, most likely in this particular case, because 11 of 14, there's a good chance that they'll be on a high-risk entity for future audits. So.
Follow up.
Thank you, Mr. Chairman. Thank you for that. I heard you say you give them a few years. I'm curious to know, in this report that I'm reading, it says internal controls lack no policies or procedures, lack of segregation of duties. It goes on and on. It says that there's census reports accuracy, that the census report was not accurate. We as the legislature use that report for many purposes. So I'm curious to know, how many years do you give them and what is statutorily required?
Mr. Chairman, Representative Lean, statutorily, there really isn't a specific requirement in terms of how regularly we go back and conduct an audit of a particular entity. And additionally, there really isn't a requirement for us to go back and actually do a follow-up as well. We tend to do that just because it's just good practice to do that. We give them a couple of years because sometimes what ends up happening is, depending on the issuance of our audit per se, it will we have to give them time. So depending on when we release the audit, we'd like to try to give them time to develop that particular, those fixes and stuff like that. And then after that, again, it's really, it's just a report to the governing body to, here's some things you can get better at, really is what goes on there. In terms of like our ability to follow up, I think it's a matter of resources available. I mean, I know that that's the worst statement I guess you could probably say to a legislator, but it really is a matter of resources. We have 6 auditors, we have over 600 entities out there that we are looking to try and get out and conduct audits. And so it's just a matter of trying to find time to get out and do some of those based on the risk issues.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Gentlemen, I too have a similar question regarding the audit for the town of Manderson. Mind-boggling. The amount of negligence, I'm just appalled by the audit. Obviously, there's some federal, potential federal consequences, specifically when it comes to like the IRS and failing to not produce W-4s, I-9s on file for any member of the town, any employee. 941 forms not on file. This goes on and on and on. No bank accounts, copies of bank account statements. It's a big wow. I mean, you can go through this audit and just highlight, and there's some major concerns because we're funding this town to operate, and there's a severe amount of negligence occurring. So there's a letter at the end of this audit that was written to your agency in May, it looks like. What type of time frame is given to get their affairs in order to comply? And then my second question is what does interaction look like between your office and these federal agencies that might hold this town liable for some of these violations?
Mr. Cummings?
Mr. Chairman, Representative Williams, okay, there was a lot of questions there. I felt I had to, so I'll try and take them one at a time. So again, our audits are mostly just informational to the governing body that we're conducting the audit of. And so we generally, I mean, the old adage, hey, we're with the government, we're here to help. That's kind of the joke. I mean, it's a joke in some aspects, but truly that's what public funds really is, the type of audits that we go out and we do. We're really out there to just go out, take a look at their situation and give them a report as to what it looks like. When the situation like the town of Manderson, the way it looked there, we consulted, do you want to go? Yeah, we consulted the Department of DCI, criminal investigation, because we had concerns with the fact that exactly what you were saying there. Basically, all of their records were missing, and we really couldn't. Without records, it's really difficult to tell what's going on with that and everything. And so there was a lot of concerns related to that. And so that's kind of where our step went before issuing the audit at all, is because we wanted to see where they were going to go with it. And they were in the middle of their investigation, and then they added this to their investigation. And at some point along the way, it was, we kept in touch with the DCI agent to see when we could release this audit, and that's kind of where we moved from there. As far as where the investigation is going, we're not clear as to where that sits at this point in time. As far as federal agencies, we didn't necessarily audit this information in determining whether or not what effects it would have had with a federal agency. and things like that. And so we just have the report out for publish just so entities are aware of it, and that's basically what it is. There was no, there was no discussion in terms of like discussing anything with any federal agencies at this point, just because we weren't sure as to what the results of the investigation were going to do, so.
Follow up?
Follow up, Mr. Chairman?
Yes.
Mr. Chairman, thank you. Thank you for that information. Alarming, really. So I'm new to this committee, but historically, and I don't know how long you've been employed by Department of Audit, either one of you, but historically, have you ever seen a situation similar to this that's occurred within the state? And has there ever been a situation where the legislature has withheld funds from a municipality or a county based on the severity of an audit? And if so, what's the default?
And I'm going to jump in here because that's one of the good ones. I would say, and maybe adding on to the question, is your department is a department of audit. So you recognize the deficiencies, you notify them of deficiencies. There's really no mechanism for you to follow up as far as accountability goes. I think we've tried in the past to tie it to revenue. And we've offered bills in the past that have tied it to revenue. And some of our legislators have decided that that wasn't the way to go, that it was more training and more, to take a softer approach. So what's your comment on that? Because again, you're kind of a department that recognizes the alarm, but then those that would be able to do something about it, like either in another department or with the legislature, what would you say?
Mr. Chairman, Representative, you raise a good point. The Department of Audit doesn't have statutorily a lot of enforcement authority. We have authority to look at financial information and issue a report. We don't have a lot of authority to make anything happen if they still don't comply. Statute affords us the authority to put them under additional oversight, which generally means we're either going to audit you more often, or we may ask you to provide financial information more often. So for example, in the case of Manderson, that's probably where we go is, hey, you need to provide information on a monthly or quarterly basis and we're just going to keep monitoring that until issues are fixed. But beyond that, we don't have a whole lot of enforcement authority. For withholding funds, that's kind of how it is for our census reporting. So all local government entities have to report their finances to us on an annual basis. So revenues, expenditures, cash, and investments. So statute says if you haven't provided that by September 30th, you're not in compliance and you have money withheld. But that's just related to census reporting. That doesn't relate to, say, audits. If we were to go in and do an audit and have findings, that statute doesn't apply to withholding funds. There's actually nothing in statute that requires them to implement any of our recommendations. And so the withholding of funds, like I said, is only applicable to the census reporting. And even that, it's only, do they have their paperwork in? It doesn't speak to if it's accurate. So for example, if they get everything in on time, but it's bad or inaccurate information, they still get their money because they've submitted what they're supposed to, even though it may not be good information.
Representative, sorry to interject on your question. Do you have a follow-up?
Mr. Chairman, thank you. If the legislative body chose to defund a town, municipality, a county, because of severe negligence, misappropriating, misusing state funds, what is the default mechanism for that town? What happens? Does it just go away? Who takes over?
Mr. Chairman, Representative Rodriguez-Williams, I don't know the answer to that question. If they were to have all of their funding withheld. For our census process, it's only a portion of their funding that's withheld. And historically, that's been enough to get them to act on things. But I don't know what happens if all of their funding is withheld.
Vice Chairman Larson.
Thank you, Mr. Chairman. So on your reports, do they go further? I mean, when you see negligence, are you, do you give it to the county attorney or the attorney general or DCI or anybody like that to, investigate?
Mr. Chairman, Senator Larson. So if we think there's criminal activity, we do refer that to DCI. In the case of just an audit where they're just inaccurately reporting, that goes to the governing body. A copy goes to Management Audit Committee. A copy goes to the governor. Sure.
Additionally, if you look at our audit reports, they also go to the county clerk if it's a special district or anything to that aspect. So it will also go to the county clerk to share with the county.
Follow up?
And just, if I may, Mr. Chairman.
Yes, Director.
Just in general, it's the governing body that should be making sure items are getting corrected. Kind of fairly common for governing bodies not to be involved in that process. Going back, a few years with this committee, we provided similar testimony on, one of the big causes is just the governing bodies not being involved in the internal control processes like they should be.
Senator Ide.
Thank you, Mr. Chairman. I've got a lot of questions on this too. I ran a bill this last session, introduced it, it failed, and it was called constitutional violations by cities, towns, and counties, essentially. And the crux of the bill was to maybe remedy things like this. What it did was you put that complaint in, it goes to the AG's office, they kind of rule on it, and you have 30 days to comply, or the state withholds your sales tax dollars to that city, town, or county. My question, I guess, to you guys is, would something like that help, rectify this situation with specifically Manderson, as Representative Rodriguez-Williams brought up? And number two, she also brought up, my other question is, the feds could potentially, the federal government could potentially be involved here. What does that mean exactly? Could you comment on that? Thank you.
Director.
Mr. Chairman, Senator Ide. So I think on your first question, our experience is, at least with the census process, that withholding of funds has tended to prompt these entities to take action and get their reporting in. So I suspect it would probably be effective in at least accelerating a timeline for issues to get addressed. Because some of the issues are not issues that necessarily take a long time to address. So if you're looking at Bear River, one of the things they don't have is statute requires you have an investment policy. That's not something that really takes a long time to develop. They just haven't done it. And so I suspect something like that might accelerate a timeline for addressing stuff like that. In terms of federal government, I'm trying to remember, because we have, in the case of Manderson, missing information on federal tax forms. Trying to remember in the past, maybe Rich will know. I know we've run into entities that just didn't pay their federal taxes that were due. In that case, I believe the IRS was notified, and, then they got that issue rectified. But in general, we specifically don't have a lot of interaction with federal agencies in terms of our audits of local governments.
This is
Senator Smith.
well, all my questions have been answered, but I have a comment. It really sounds like to me, unless DCI gets involved and there's criminal intent, so there could be massive negligence, but unless there's criminal intent, there's not going to be a DCI case. But with that said, there's really no teeth to anything you can do, and it doesn't sound like there's anything in place that you guys know of that we can do. Is that correct, as a legislature?
Mr. Chairman, Senator Smith, I would concur. There's not a whole lot that, a lot of enforcement authority that we have. And if there's nothing criminal that either the AG's office or a county attorney wants to pursue, there's not a whole lot within statute.
Director, I have a question. So this is an ongoing problem, has been forever, and you stated, I think, the problem is Wyoming is a rural state with many, many different cities, towns, and counties, some very small. But this goes into improvement service districts, water districts, where they form to accomplish something, and then kind of just forget about it after it's accomplished. And it's an ongoing problem that we seem to have. You would think maybe a clearinghouse through WHAM or WCCA, as they pay their dues, to have some authority or some, at least expertise, to help these smaller communities. What would you recommend?
Mr. Chairman, in terms of trying to address some of the issues.
Yes.
I do think withholding funding, like I say, our experience says that tends to spur some action, especially for stuff that's, like I say, not real time intensive or difficult to address. Some of the accounting issues, there is a severe shortage of qualified accounting or auditing professionals. Any organization that's tried to hire accountants or auditors can probably speak to that, particularly in the government arena. I think trying to leverage other entities could be an option. I think in terms of accounting help, I think it's probably easier to get, say, CPA firms to aid in accounting than it is to get CPA firms to audit. And so that could be an avenue. If it's maybe WHAM has a standing contract with some firms to help provide accounting services.
All right, thank you. Yes, Representative.
Thank you. I've been on management audit for a hot minute here. So for some institutional knowledge, this was House Bill 60, legislative session 2022, was something that came out of our work. It's fiscal training and enforcement of financial reporting laws. I'll send this to the committee via email, but essentially this is the carrot and stick approach in terms of requiring that training, but also the option to withhold funds, grant or loan dollars until the entity comes into compliance. So I'll send this out to the committee for a review.
I appreciate that. And I think that's where it stalled, was the accountability part in session is what I remember. But any other questions? Yes, Representative Rodriguez.
Mr. Chairman, actually, question is for the good representative who just spoke of that report that she's going to share. Was there any discussion or, and maybe this is for the good gentleman too, is there anything that was discussed in regards to like emergency circumstances where you can put a freeze, or who has the authority to enact an emergency type of freeze on a municipality, town, or county in these type of situations?
Representative.
Thank you, Mr. Chairman. Great question. I don't recall that conversation. I think emergency is our favorite word of the day, though, so I'll just say that.
Yes, Representative Lean.
Thank you. Thank you, Mr. Chairman. Rules have been a hot topic today, and I'm wondering if your department has generated any rules to be able to have compliance within statutory intent.
Mr. Chairman.
Director.
Representative Lean, we do have rules in terms of what reporting is required and what timelines. But again, beyond that, there's no, I'll say, enforcement authority. I don't know that we could promulgate rules giving ourselves enforcement authority that statute hasn't given us.
Senator,
Yeah, thank you, Mr. Chairman. Real quick, in the case of Manderson that we've been talking about here, would, in your audit, do you comment on the constitutionality, or do you have to wait for, AG's opinion or anything like that? Do you guys actually do that in your audit, reference this is a constitutional violation? Thank you, Mr. Chairman.
Mr. Chairman, Senator Ide, if we see something that we think could be, we do mention it. The most common one is donations. So if we run into a government entity that has made donations, we will identify that as a constitutional issue. So if we see it, we do indicate it.
Mr. Chair, I got an unrelated question to this
Senator
topic when we're ready. It's unrelated to this.
Oh, okay. I had one last question. So I know that there's a problem within the state of Wyoming to find auditors or accountants that do auditing anymore. Do a lot of these smaller communities rely solely on your department to look at their audit?
So, Mr. Chairman, so the smaller entities, yes. So statute requires cities, so population of 4,000 or more, to get a CPA audit. And then other entities, hospital districts have to have a CPA audit. And then special districts whose revenues or expenditures exceed $1 million have to have a CPA audit. Everyone else falls within our purview to look at. So I won't say all your towns. So your towns aren't required to get an annual CPA audit. Some of them elect to, the vast majority do not, so they would fall under our purview for audit. Same thing with any special district that's under $500,000 would fall under our purview, which is the vast majority of the special districts. It's probably, you're talking probably 5 of the 700-ish would fall under our purview.
Thank you. Oh, go ahead, Vice Chairman. He's going to do a different topic, so.
Mr. Chairman, thank you. So as legislators, do we have can we request your department to do specific audits?
Mr. Chairman, yes. So we have in the past, The one that comes to mind is years ago, the legislature asked us to audit the school facilities department from inception to that current year. So yes, the legislature has requested us to do audits in the past, and we have.
Follow up?
Yes, Mr. Chairman, thank you. So if we requested that, would you contract that out, or do you have individuals in your department that would do that?
Mr. Chairman, Senator Larson, it would depend on what the audit was. If it was something that we have expertise in and capacity to do, we would do it. If it was something that was beyond our expertise, is something that we would then say we probably need to contract that out. Timeline would also kind of matter, if you're looking for something turned around quickly versus a longer time frame would factor into that decision as well.
Mr. Chair, that kind of plays right into my question that I have.
Go ahead,
for that.
Senator Smith.
That's actually, so thank you, Senator Larson. So gentlemen, by the way, I'll make a quick comment here. I know we're short on auditors, but if you two wanted to double as detail for the governor, you could. These guys look like Secret Service agents here, don't they? With that, then thank you for the audits that you sent me, that you sent us. I requested that, and you guys sent that right away. I appreciate that. And my question is, I'm getting a lot of questions from my constituents. They just don't trust government right now. And we like you guys. We know you guys are doing a great job, and we love our government employees. My question is, have you ever audited? So I'm getting questions about who looks over you, and specifically who looks over the legislature, who audits us. Have you ever audited us?
Mr. Chairman?
Yes, Director.
Senator Smith, we have not audited the legislature. We don't have statutory authority to audit the legislature. Statute provides that we have authority over state and local government entities, but statutorily, we don't have authority to audit the legislature.
Okay, so we would have to direct you to audit us.
Mr. Chairman, Senator Smith, yes, we could do something like that by request, but we couldn't do it on our own.
Okay.
Follow up? Yes, Representative.
Thank you, Mr. Chairman. Gentlemen, I was looking at your website, and I noticed that these audits are not on your website. Your strategic plans are up, but not these audits of these municipalities and documents that you provided us. What would it take to make these public record? I mean, obviously, they're listed as meeting materials for this meeting, but how about posting them on your website? Any thoughts?
Director.
Mr. Chairman, Representative Rodriguez-Williams, so all of our audits are on our website. So if you go to the Public Funds Division, up top, you'll see you could select public funds, and then under public funds, there's audits, and then it's categorized by towns, special districts, school districts. So all of the audits we do are on our website, as well as now the most current audit of all the municipalities. So everybody that's required to get a CPA audit, all of those audits are out on our website. So.
But could you Facebook shame them? Representative Lean.
Thank you, Mr. Chairman. I want to walk backwards to some of the history that I have found in regards to the Department of Audit. I'm going to go back to 1971, and we have legislation passed here that, I'll have to get you the statute number. On page 2, it says there's an appointment of a director of office and the legislative auditor, staff, salaries, and expenses. When I read through this, I see this as the director of office would be our director, Matt Obrick, and our legislative auditor would be you, our director of audit. And then when you jump ahead to 1977, it was originally House Bill 485. I'll have to get you a current statute number, but it says in here, to this end, the legislative auditor shall periodically conduct post audits. And then you further on through, it says an audit report to management council and to each member of the legislature when directed The legislative auditor shall audit any entity receiving state funds. So to go along with the good senator's question about who audits LSO, they receive state funding. Would you be willing to audit the LSO department?
Mr. Chairman, Representative Lean, if we were asked to, sure.
Mr. Chair,
Yes, Senator.
may I make a motion? I'd like to motion,
Yes.
and thank you, Representative Lane, that was great. And by the way, I'm certain that there's nothing fishy going on at the LSO, but we have to sweep our own porch before we can look at everything else. And so I think right now would be very appropriate for me to make a motion. I'm going to, that we direct this Department of Audit right here to perform a performance audit of the LSO and to look at expenditures, revenues, contracts, procedures, and controls. And that would be my motion.
Okay, it's been moved by Senator Smith, seconded by Representative Lean on the, I'm sorry, go ahead.
Just a discussion on it. So a couple of thoughts. First, we don't have the power to direct them. We have the power to request of them, which is something that is a big issue with regard to separation of powers. So even though we asked them before and they did, the answer could have been no. So I think it's just important to realize that that was just a cooperation, and it was an executive branch entity that the answer was to. Second is from a separation of powers standpoint, typically we, the legislature, and again, no offense, you guys do a great job, would not use the executive branch as our auditing entity. We would do something internal or hire external and contract for that service, where it could be in negotiation with them, but through the management council, figure out who would do that audit. So not to say that it's a bad idea to do an audit, but having the executive branch audit the legislative branch is not, in my view, and perhaps it's just my view, but it's not an appropriate respect for separation of powers between the agencies. It's not something that I would support for that reason. And again, we have the capacity to hire an external third party to get that done. We could do that if that was desired. But it's an awkward thing to have one branch audit another branch in that capacity. And so I would discourage the motion.
Mr. Chair.
Yes, Senator.
I'd like to respectfully just maybe have a different perspective than the good senator from the County of Higher Learning there in Albany County. I think it's clear from the Constitution, you got Article 4, Section 14 gives the power of oversight to the legislature. And then you got Wyoming Statute 28-8-107, and it clearly says that management audit can request performance audits. If you go down to Section B, Romanet 1, capital B, it's in there. So we can request that, and so it's completely constitutional.
Okay, any other discussion?
Chairman?
Yes.
Just to respond to that. So you can't necessarily use the statute and then say a performance audit of the legislature and get to the constitutionality, but even if it is constitutional, is it the advisable approach to have the executive branch having oversight over the legislative branch? The answer is no, it's not. Nor is it appropriate for the legislature to come in necessarily and do the same thing, right? It's within the executive branch. It's a typical separation of powers where legislature respects its own court, we regulate ourselves, we do our own work, we audit ourselves. And again, we can hire out for that if there's a desire not to be grading your own homework. I respect that. And same thing for the executive branch. But I guess I would say this, maybe let's not have the motion concluded today. If this is a direction that everyone wants to go, maybe we dig into this a little bit more, get a little more information, perhaps talk to folks in the management council as well to see if that's a desire. Talk to our LSO director. Would it be desirable to have Department of Audit be the auditing entity over the legislature? We don't have to make this decision today. I don't think the good senator's probably in a great hurry to get this done. So maybe we give this one a little bit more thought, even if you're thinking this is the right idea. I would encourage that we not take that action today. We investigate the appropriate process a little bit further and think about what the right way to audit the Legislative Service Office would be.
Senator Smith, do you have a comment?
I think it's clear from the statute and also from what Representative, the good representative over here said, that that authority probably, you guys probably should be under the authority of the legislature, but you're not. And we're following the proper steps, and we're going to direct you, if that's the motion that's on the table, to do just that, to audit us.
Representative Lean?
Thank you, Mr. Chairman. To the good senator's point, I just want to know if this would be seen as a checks and balances system between the two branches of government versus we're trying to throw oversight over each one of us. It just would be deemed a checks and balances system between the legislative body and the executive branch.
Senator, you have a comment?
I don't think that's necessarily anticipated. It could be thought of as a check or balance. But again, I guess I don't know what the hurry is. This wasn't on our agenda. Certainly not something we considered before. The idea that we rushed through on this motion without maybe getting some feedback from LSO on what the appropriate approach is, talking to folks in Management Council, it's just a sensible approach to be a little bit cautious, a little bit conservative on jumping in to this motion. And again, the idea that we have the capacity to provide clear directive. I was trying to pull up the statute real quick to take a look at it. I don't have it in front of me. My apologies for that, but I think it was 21.8, and I'll take a look at it. Providing directive from a committee to, and again, as legislators, we are not executive branch. We don't have a great deal of authority, but we do have some authority typically within the legislative branch. Providing directives from a committee to an executive branch entity is usually regarded as a violation of separation of powers, which is why we usually phrase in statute, we request something along those lines. And this legislation, this statute, predates me in the legislature. So, I wasn't around when it was drafted for Management Council. But in the 15 years that I've been, we haven't cleared any legislation that has said we get to direct the executive branch to literally do anything. Nothing hasn't been vetoed because it's typically seen as a violation of separation of powers.
Vice Chairman, did you have a comment?
At some point.
Oh, Mr. Chair, I'd just like to, I'd accept a modification of that motion, just to, that this committee requests the Department of Audit and everything else leave the same, if that would be amenable. I mean, it's amenable to me as sponsor of the motion here.
And Mr. Chairman, I'll just say that then becomes constitutional. So I appreciate that. I think it's ill-advised for the reasons that I mentioned before. And I think we should still look into it more. Again, I guess I would ask the senator, if I may, Mr. Chairman, why are we in a hurry to do this motion today? Why can't we investigate a little bit and get staff in here from LSO that can advise us on it directly, that have experience in this particular space?
We only have one more meeting, and this committee has to get some things done. That's and Mr. Chair.
Through the chair, yeah. Vice Chairman Larson, are you going to wait? Okay. So just to clarify the question, if requested, you could do the audit, correct? And
Mr. Chairman, yes.
that falls within your purview, so. Representative Lean.
Thank you, Mr. Chairman. Just food for thought for the committee. I want to offer 28.8.107. Let's go to D, Romanets I. And they just talk about whether the funds have been legislatively expended within legislative intent, and that the Department of Audit and the LSO are to oversee that. And so with that, I believe that this motion is in line to make sure that we are, like Senator Smith said, taking care of our own doorstep first, that we're making sure that everything that our team is working on is within the bounds and confines of legislative intent. And so I therefore support this motion and look forward to seeing the audit.
All right, you ready? Oh, Bob, Senator Hyde.
Thank you, Mr. Chairman. Yeah, it's a good discussion here, actually. I'm in favor of the motion. I mean, it's, as the good senator from Albany County brought up, the only other alternative is to, get an independent outside audit, and that costs money, taxpayer money, not our money. And we've got the resources here to do it. The argument on shall and request, I have a little issue with that as well, too. I mean, throughout our Constitution, it's got shall in a lot of places. So, it's up to the bringer of the motion, but shall is a little stronger word than request. So I'd be in favor of that. Thank you, Mr. Chairman.
All right, we do have a question from Senator Larson.
Mr. Chairman, I don't know if this is on the topic of that, but I would like to ask the department if you know in past, has the Department of Audit been underneath the Legislative Service Office? I've heard that it had.
Mr. Chairman, Senator Larson, the Department of Audit has not. Since its creation in 1990, it's been established as an executive branch agency.
Follow up?
Mr. Chairman, so do you know, did the legislature have a separate auditing agency or something? Employees or such?
Mr. Chairman, Senator Larson, there at one point was the Office of the State Examiner. I don't know if that was executive branch or if that was under the legislature. I couldn't tell you if the legislature had its own audit function previously.
We did have some head nods in the audience of people that have been here a while. If you do want to come up and just maybe answer that question. Our state auditor.
Mr. Chairman, Christy Racina, State Auditor. I am so sorry because I know just enough to be dangerous, and I am probably maybe the least bad person to answer the question, but there's better people. Mr. Chairman, under LSO, there used to be a quite robust performance audit section with dedicated employees and a dedicated director. I would certainly look to Director Obrecht to provide you more information on that. But in my understanding, all of those statutes apply to management audit oversaw a whole section of LSO which regularly reported to management audit, and there was a director of that division. There was multiple auditors dedicated to that purpose, and it was completely separate and apart from the Department of Audit that has always been in the executive branch. And sorry for nodding my head from
Oh, thank you for answering that. I appreciate it. Senator Rothfuss.
And Mr. Chairman, as I'm reading through 28.8.107, and maybe I'm missing it because I'm reading too quickly, I guess I'm struggling to understand where this motion is derived from, because it all seems to refer back to exactly what the auditor was talking about, which was the former internal function of the LSO, our own audit through the Legislative Service Office, not the Department of Audit, which is through the executive branch. So I guess I'm missing the authority that we're operating under here. And if I may, Mr. Chairman, ask the representative or the senator which aspect of 28.8.107 we're referring to call for an audit from an external agency of the executive branch, as opposed to an audit through the Legislative Service Office, which I have no problem with directing the LSO to proceed with an audit of the LSO and effectively have to hire externally.
One of you two want to take that? Representative Lean.
Mr. Chairman, just to your point of having the LSO audit the LSO, that to me seems a little more non-transparent than one branch of the government auditing the other branch of the government.
All right.
Senator Smith, you want to add to that?
Yeah, Mr. Chair, to the good senator here, I yielded on the term instead of direct. We request that the Department of audit us. So that kind of does away with the argument that it's not proper. We're requesting that it be done. And we're requesting it be done because we're looking at the entire government. And until we sweep off our own porch, we can't go and look at other agencies in good conscience. So that's where we're at. And I don't think we need any more debate on this.
Mr. Chairman, I do.
Senator?
Yeah, I think we do need more debate on it. So, all right, I appreciate the fact that the language isn't there for us to direct. That's good to clarify. The request becomes constitutional, but then again, I guess I'd look to the authority that you have to come back through statute. Is it actually there that you have the authority to provide an audit to the legislative branch statutorily? Can you point to somewhere in the legislation, or excuse me, somewhere in statute that indicates that, is my first question. And second is, this might be of concern to the governor as well. So you saying that you're willing to do it, is that tantamount to the governor saying, yes, this is something that we would engage in?
Director?
Mr. Chairman, Senator Rothfuss, statutorily, we wouldn't have, I'll say, our own authority to audit the legislature. So I think if the legislature were to ask for it, I think we could. And on the second question, I can speak to the governor's thoughts on something like this.
Okay. So, Mr. Chairman, the way that I read 28.8.107, we can bring a motion to direct LSO to audit LSO. That is in order. And as Representative Lean noted, that's grading our own homework. That's a problem. And typically when you're grading your own homework, you simply hire outside and find a way to contract it, right? That's what most entities do if they want an audit without grading your own homework. You hire an external auditing firm, and that external auditing firm isn't going to make things up if they're accredited and certified. That motion is in order, and we can do that. And I think that's reasonable and appropriate with regard to the authority. I think specifically directing, and I guess I might even call on LSO to get their analysis on this. I think we're stepping outside the bounds of what Management Council is able to do to even request of the executive branch an audit of the LSO as I read 28.8.107. I mean, it is requesting that LSO do an audit of an agency. That's the authority of this committee. And that is not the motion.
Representative Lean.
Thank you, Mr. Chairman. 28.8.107A, the Legislative Service Office, at the direction of Management Audit Committee, subject to Management Council budget priorities, the subject to general practice policies established by the legislature, when in regular or special sessions, shall audit the accounts and operation of state departments, agencies, commissions, boards, institutions, programs within the departments and any entity directly or indirectly receiving state funds. Mr. Chairman, the LSO receives state funds and we operate on the tax dollar. I still second the motion that says we have the legislative authority to give direction to have this done.
So I'm just going to clarify, your point is that we can direct to have it done, we just have to direct it through the LSO, according to
Yes.
28.8.107 BC?
Mr. Chairman, that's correct. And then when we're doing contracts, typically those contracts go through Management Council because we don't have contracting authority. So it would be a contract that would be approved. That would be my understanding. And so, yes, we have the right pursuant to the A paragraph, as Representative Lean just noted, to make a motion to direct LSO to do this audit. Absolutely true. We don't have any right to engage or determine who's going to do it, or the executive branch at this point in time, we're directing LSO to do it. And I think that motion's in order.
Could we direct LSO to direct the Department of Audit to do this audit? That would comply with the statute.
I don't think so.
Senator,
Yeah, thank you, Mr. Chairman. You know, if we do move forward the way the motion is proposed and the executive branch, AG's office or whatever says, you know, there's nowhere in statute that you have this authority, we'll probably hear about that at that time, won't we? Can you answer that question? Thank you.
Mr. Chairman, Senator Ide, that I don't know.
in my opinion, we're in line with that statute if we direct LSO to direct the Department of Audit for this particular audit. Josh, Mr. Anderson?
Mr. Chairman, and I think that's a deeper question we'll have to look into. I did want to note that we do have on our website, if you go to About the Legislative Service Office and under Financial Information, we do have a biennial audit of our financial records. That's up there, the most recent one from 2024. So we do have audits posted from LSO, from an auditor that are done every 2 years, that you can see on our website.
Mr. Anderson, is that an independent audit?
Mr. Chairman, that's an audit. The last one was done by McGee, Hearns and Pies.
What kind of audit, Mr. Chair, what kind of audit was that?
It's a financial and compliance audit, Mr. Chairman.
We're requesting a performance audit. I'm okay, Mr. Chair, if your friendly amendment here is to motion that this committee direct LSO to request the Department of Audit. I'm okay with that, because the point is, we want to sweep our porch. We want accountability, the people want accountability, and we shouldn't be blocking that. And whether it's an outside entity or whether it's a Department of Audit, we need to take care of business at the LSO.
Well, I honestly think it may help because we're looking at adding employees as well. And that performance audit may give some light into that answer of how many do we need and where we could go with that. So, yes, Representative Sherwood.
Thank you. And thank you all for the conversation. I just want to add some clarity, and I will send this out in an email. I was looking up the same thing you were, and I'll send out that audit that was done for the state legislature that ran through 2022, concluded at 24, by a third party. I will send that out. But I want to clarify that a financial audit is different than a performance audit. And my understanding, I'm not sure what we're asking for, because the Department of Audit is about financial performance. I'm not sure that you guys have the staff to do a performance audit. Not sure, just asking for clarification. I think we need to understand what it is we're asking for. Are we asking that LSO staff is firing out on all cylinders? Are we asking for transparency in LSO's budget?
Director, could you answer that question of performance, please?
Mr. Chairman, Representative Sherwood, yes, we do have the staff or expertise to do a performance audit, yes.
I'm going to allow one more piece of discussion, and then we are going to vote. And I want to make sure that we have both the motion and the amendments clear and seconded, and then we'll go forward. Senator Rothfuss.
Thank you, Mr. Chairman. So again, getting back to the concept, they work for the governor. That's their job. A performance evaluation of the Legislative Service Office. Whoever we hire needs to work for the legislature. They need to work for the House and the Senate. And that's who they should report to. They don't get to do that. That's why we don't hire them to evaluate the legislature. Now, we're in a good time right now. They're great. We like them. I like the governor. I like everybody in the executive branch. I probably have better, thoughts and feelings for many folks in the executive branch, perhaps, than the folks on this committee. But there's a reason for the separation of powers argument. We don't hire the executive branch to come in and tell us whether our legislative service office or we, the legislature, those that we hire, are doing the right things, are doing a good job, right? That's literally the separation of powers. I don't have any problem with the concept that the senator's bringing about having an audit of the LSO. That's great. It makes perfect sense. We do the financial audit. We haven't seen a performance audit. That makes good sense. I don't have any concerns about that. My concerns are only the fact that we're trying to save money so we don't have to hire anybody external, and we're willing to violate the separation of powers in the spirit of the violation of separation of powers because we don't want to spend extra money. And to me, that's a bad choice. To me, the legislature is in charge of the legislature, the executive branch is in charge of the executive branch, the judicial is in charge of the judicial. And we don't hire executive branch to provide a performance audit of whether the executive branch thinks the legislature is doing things right. It doesn't make sense. It's not their mission, and it's not their chain of command. When we hire an auditing firm, they have a responsibility, a professional responsibility to answer to us, right? They're working for us, and they're going to do what's in our best interest. They have a direct responsibility to serve the governor of the state of Wyoming, a good friend of all of ours. But it's their job to serve him. That's the separation of powers argument. And I hope you're persuaded that maybe we could give this a little bit more thought. At the very least, kick it to the next meeting. But if not, let's direct the LSO to do an audit instead of asking them to do the audit. And we sort those details out later as far as who does the audit, so we can have more conversation about this. Bring in the LSO director, have a conversation with the governor about whether he's comfortable with this. It's okay not to do it all today. All right? I don't know why all of a sudden we're operating at the speed of now instead of the speed of government, when this one might be one we can reflect on for just a couple of minutes, particularly since it wasn't even posted in our agenda. No one saw this coming. We could vote over email, Mr. Chairman, in a couple of days upon reflection, if we wanted to. It's okay to just pause for a little bit and think it through.
Mr. Chair.
Yes,
This is not about the money. This is about checks and balances. This is about embracing accountability. And we're asking the executive branch to audit us, which is our authority to do. And everything's in line. I don't get the argument that we should wait. We only have three times that we meet. And it is time that we start functioning as an auditing committee. We're the management audit committee, and we should act like it. And it starts here. It starts with us. These guys have the capacity to do so. We need a performance audit so that we can evaluate ourselves. And like you, that was a great point that you brought up, Mr. Chair. We are looking at hiring a couple employees. Let's see if that's even necessary based on what comes back.
Okay, I'm going to make the last comment here, and then we're going to restate the motion, see if there's the second with the amendments, and then we'll vote on it. But I do think this way we are within statute, number one. I look at it as the Department of Audit being an independent source for us to use for the audit. And if it's a request, I think that it helps us, and as stated, I think that it's okay to look at ourselves first. It's okay to do a performance audit and see what we need. That's not a problem or an issue, I wouldn't think. I realize their financial audit is online, that's very good. But I'm going to ask you to restate your motion with amendments and then see if the second concurs and we'll go for a vote.
Okay. Mr. Chair, I motion that this committee direct the LSO to request the Department of Audit to perform a performance audit of the LSO to look at expenditures, revenue, contracts, procedures, and controls.
Okay, we have a motion and the second. I'm going to go ahead and do a roll call vote on this, just so we have it. Tanner, please, thank you.
Mr. Chairman, this is a roll call vote on Senator Smith's motion. Senator Ide.
Aye.
Senator McCune.
Aye.
Senator Olson.
Aye.
Senator Rothfuss.
No.
Senator Smith.
Aye.
Representative Lean.
Aye.
Representative Locke.
Aye.
Representative Rodriguez Williams.
Aye.
Representative Sherwood.
No.
Vice Chairman Larson.
Aye.
Chairman Knapp.
Aye.
Mr. Chairman, there are 9 aye and 2 no.
Okay, that motion does pass. Moving on. We do have scheduled the state auditor. Welcome.
Well, Mr. Chairman, now that everybody's blood sugar's low and anyway, my name is Christy Racinas. I'm serving as the state auditor. I have some sense of why I may have been called here today, but knowing you're short on time, I'm happy to just take questions, or I can give a 5-minute overview of what my office does and doesn't, maybe for your purposes. I think my goal is to maybe clarify some confusion around where auditing happens and where auditing doesn't, if you want me to proceed in that manner.
I think that would be helpful. Thank you.
Sure. So, Mr. Chairman and committee members, and some of you will know this already, but some of you may not. The state auditor is essentially the comptroller for the state of Wyoming. So what that means is our primary duties are to cut the checks and keep the books. If any of you received a payment from the state of Wyoming, which I know that all of you have, that has come from my office. We also are the chief payroll officer for the state of Wyoming. So, 8,000 payroll payments a month. That includes all 3 branches, the National Guard. We do all of the checks, EFTs. We do all the calculations for taxes. We remit those payments, and then we do all of the reporting for all of that to the IRS. And then we also are responsible for issuing 1099s on vendor payments for the state of Wyoming. Additionally, we're required to maintain the electronic accounting system for the state. I'm guessing some of you in some of your businesses may be familiar with like QuickBooks or something like that. So I always say, like, if you take QuickBooks times 100 on steroids, that's essentially the level of accounting system that the state needs, because we are such a huge, complicated endeavor. And so we need a system that is capable of capturing all of that information. And statutorily, my office holds that contract, manages that system, and that system captures every in and out dollar-wise for the state of Wyoming. Our last big statutory duty, and I'm going to introduce Erin Benskin, who's the head of our accounting division, and this is her job, is to produce the financial reports of the state. So similar to a business, the state of Wyoming has a balance sheet and income statement. This production is about 250 pages long, and it is known as the Annual Comprehensive Financial Report, or the ACFR, otherwise known as the ACFR. So if you hear that acronym thrown around, that essentially means the big giant balance sheet and income statement for the state of Wyoming. We're required to produce that once a year. Now, and when I say we, I mean Aaron and team, how we go about that is we have to gather up all sorts of information from every agency in the state of Wyoming, including some outside entities that are still part of the state, for example, UW, and combine that into this gigantic report, bring it to generally accepted accounting principles or GAAP, and make sure everything is in alignment. Now, the next step, of course, is an external CPA firm comes in and checks all of that and audits our work as a state of Wyoming, as the entire state, to make sure those statements are presented fairly and accurately and free from material misstatement. So we have a pretty small office. We're 23 people total. I think I'm the smallest of the elected officials. And those duties, of course, those are more back office things. I'm not going to talk about my roles on the boards and commissions today, because that's not what you're dealing with. Those primary duties of the state auditor have really remained unchanged for several generations, apart from that the accounting system has been electronic for the past 35 years or so. We do not do auditing in the sense of the way you're using the word. So my office it's a little bit of a misnomer in the sense that I'm called the state auditor. What we are doing is auditing payments for completeness before they're paid, if that makes sense. You know, when one of you receive a payroll check, we're making sure it's been calculated correctly, deductions are proper before money goes out the door. There's somewhat of a misunderstanding or rumor, I'll say, that the state auditor used to do a bunch of auditing and then that was removed from this office at some point. If you look back through the statutory history, and I did bring my handy dandy 1989 Ferrari report, which is a fascinating document. And it's amazing because you all are saying some of the lines are shockingly relevant today. But what happened back then essentially is there was no Department of Audit. Legislature came in, and I'm generously paraphrasing here. Legislature came in and said, we need to do a better job at auditing. We need to have it centralized. And that's when the Department of Audit was created. Now, the state auditor at that time did have a very small audit function and only audited FMRs, Federal Mineral Royalty Programs. And at that time, that was removed from the state auditor's office. There was also a couple other small auditing functions. I think that OSLI did some that were then combined into the Department of Audit at that time. Mr. Chairman, again, knowing you're a little shy on time, I promise I hate to come and just tell you all about all the things I don't do, but that's sort of how we fit in and then don't fit in occasionally in the auditing function. Happy to take any questions.
Questions from the committee? Vice Chairman Wasserman.
Mr. Chairman, thank you. So is there at some point in history been maybe changed your title to comptroller, state comptroller? And what would that entail? Is that change all our statutes?
State Auditor.
Mr. Chairman, Mr. Co-Chair, great question. I think because I have this conversation a lot with legislators, or I get the occasional stray call from constituents that I then have to kick over to my friend Justin at Department of Audit. That would be more accurate, but the process of going through that constitutional change and then trying to pitch that seems, I don't know if it would be, I don't know that the juice would be worth the squeeze or not. And Mr. Chairman, I would note, I think that the treasurer suffers from some of the similar problems. When I think of a treasurer, I think of the person cutting the checks. That's my job, and it's always, so I'm not the only one that suffers from maybe a little bit of just, back when this position was created, before Wyoming even became a state, a CPA audit that we're all talking about here, that wasn't a thing.
Any other questions? Senator McEwen.
I think I just want to make sure I understand this, so I'm going to put it in business terms. And I'm not trying to be ornery with it, but you're basically the state's bookkeeper then, is that correct?
Mr. Chairman, Senator McEwen, I would not disagree with that statement. Again, recognizing, I don't think being a bookkeeper is a bad thing. I think it's incredibly important. The complexity of the state, the number of zeros and sources and inflows and outflows we have. Yeah, I'd say that's accurate. And again, all of the payroll and that calculation and reporting function as well.
Follow up?
Well, on that, Mr. Chairman, on that note, I have an accountant and a bookkeeper. And I like the bookkeeper a lot better most of the time because she does more. Thank you.
Mr. Chairman, I resemble that remark.
All right, any other questions? Okay, thank you.
And Mr. Chairman, we're always happy to come and now this committee's making me feel old when I remember things that, I did look it up, that section of LSO, and again, I would refer you to LSO, of course, was called Program Evaluation, and all of the audits they did are still online, and some of the main ones, and please, Mr. Petrie, correct me if I'm wrong. For example, ETS was born from a report that came out of that Program Evaluation Division. That was a big one. Senator Rothfuss would probably remember some others, but that was a massive change that came from that legislative function.
Thank you. I'm glad you were here to provide insight on that.
No problem.
When we needed it. Okay, with that, is there anybody in the audience that would like to comment or have question? Mostly comment. We don't want any questions.
Okay. Mr. Chairman, Rush Schriftman again. Just a couple comments. Representative Rodriguez-Williams brought up what the responsibility would be if a municipality was grievously in trouble. I was just thinking, if my memory serves right, there was a city of Camden, New Jersey, that the state took over with I think, appointed special master when there was administrative management problems with the city, crime, other things, until the city got back up online. Secondly, to the Department of Audit, I'm in a city of Casper, and so the city has CPA. And I understand the problem with a lot of CPAs don't want to do this municipal work for the larger communities. And possibly there's also a conflict, even though a CPA firm has an ethical responsibility, they're auditing and they're then reporting and they're being paid by the city. So there might be consideration of maybe the Department of Audit do all of the municipalities and organizations within the state. That would take a cost off the local governments, and of course, they're all crying that they're losing revenue from the state on the property tax. So that's one other thing. And then I forgot to mention something. It's been brought up a couple times about emergency rules. And of course, we all went through the coronavirus scare a couple of years ago. And in Pennsylvania, the governor acted, I guess, under a broad public, protecting the public safety, and put a emergency rule in, shutting down the businesses. Very significant economic impact. In May of 21, the voters of Pennsylvania approved a constitutional amendment which required the governor, after 20 days of an emergency, to come back to the legislature to get an extension. So it could be a natural disaster, it could be a terrorist attack, whatever it might be. But he is now required to come back to the legislature after 20 days and get an approval for an extension. So if you have any questions.
Any questions from the committee? Okay, thank you.
Thank you.
Appreciate it.
Sure.
Please come up, introduce yourself again, even though we've seen you already.
I'm sorry, I'm fairly hard of hearing, sir.
Go ahead and introduce yourself and then whatever comments you have.
My name's Kevin Lewis from Laramie County, and it's kind of an interesting conversation. The last meeting, I believe Director Obrecht testified that he had poached everybody out of the program evaluation, and there hadn't been a program evaluation since 2018. This leads to all kinds of questions, right? You know, if you want to audit LSO, you can't do it through the program evaluation division. They're poached. So it's in regards to the separation of powers, you often see lines crossed. So for instance, you might see the Department of Audit a court. In particular, recently we've had embezzlement from a court in eastern Wyoming, and they may have done that audit at the request of DCI. It can happen, right? They may cross lines on request because law enforcement may ask for it. Oftentimes you'll see statutory crossings of separation of powers. You know, the governor behaves as a legislator when he's line item vetoing bills or rejecting them entirely. And oftentimes you see executive branch courts. In your rules discussion, executive branch courts can change your rules that are written by executive branch agencies directed by the legislature. It's a really interesting conversation. It's not perfect. Sometimes it rides a really fuzzy line. But the problem that I see in Wyoming is that we don't do enough audit. We really do need to do more audit. And that audit power rests constitutionally with the legislature. An example would be the city of Rawlins. City of Rawlins had a failure of their water system. It was a big failure. It wasn't a slow failure. It occurred over a long period of time. The pipes were 100-year-old pipes made out of wood. However, if they'd had an audit, say in 2000, that looked at their municipality and the performance audit of their municipality, it would said you weren't getting paid enough by the users and you're not physically maintaining the system. We've paid for that system many times over. They got $7.5 million of ARPA funds. They got $675,000 of SLIB funds. And people in Rawlins now tell me that they're worried about their sewage plant, which the last time their sewage plant failed, it was SLIB funds. The time before that, it was SLIB funds. The audit for Rawlins is a financial audit. It doesn't uncover those performance items. So it may look great. They look wonderful on their financial audit. They have excess revenues of about 10 to 14 million, if I recall. They look like they're sailing along fine. I'm not sure that they are. You see these small towns almost all the time in the Department of audits failing to maintain their municipal water systems or sewage systems. But that'll never get caught on a financial audit. It gets caught on a performance audit. And this is a hard discussion. You're going to spend some money to do more audits, but you need to spend more money to do audits to save the money. It would be much better to not have water facilities fail because they aren't doing their depreciation schedules correctly. They're not collecting enough money to maintain them, or they're physically not maintaining them. And you're only going to find that through audit. And that saves the state of Wyoming a lot of money. It's interesting in various states. I've done the research a long time ago. Half the state, well, 40% of the states have an executive branch audit function, an elected auditor that will cover the state. 40%, the audit function lies in the legislature. Because the legislature appropriates money, they have the power of the purse. So they have the power of the receipts and check the receipts and do the addition and subtraction. And 20%, like Massachusetts, is a shared responsibility between the executive branch and the legislative branch. And it's fascinating. I actually called up the auditor in Massachusetts, and he claims he's the oldest bureaucracy in America. He was founded by King Charles. He survived the revolution. So, but it's worthwhile to note that oftentimes the legislature has the power of audit. And it looks to me, through the history of LSO, it starts in 1971. It has two co-equal directors, a director of office, a director of audit. That proceeds towards 1990. In 1990, you have that constitutional amendment quoted by Senator Smith. And that puts the audit power into the legislature. So it looks like the legislature was always trying to have some power of audit, and it probably needs to be exercised. If you have that power, you should wield it, and wield it wisely. I think you would find that spending money on audit has a return. It'll look a lot like a Laffer curve. If you do far too much audit, you're spending too much money. If you do enough audit, you get the best return, and you send a message to the state, these are the controls you need to exert, and these are the ways you need to operate, especially in a small state where people need to learn how to manage these monies and these public funds for public benefit. So I highly recommend that you continue on the way and figure out how to get that power of audit utilized.
Questions? Yes, Vice Chairman Larson.
Mr. Chairman,
Yeah,
I have a question for Mr. Lewis. So how many employees would it take, I mean, for the legislature to, in your opinion, to perform audits like we should be doing?
I don't know that you need to, I'm sorry, Mr. Chairman, Senator Larson, I don't know that I would actually have that number. This is a really interesting question. I went back to the archives. I went through the last state examiner's correspondence. There was a lot of correspondence between him and the governor at the time. It was state examiner was Stanley Hunt. And in his correspondence, he says, my public funds division is the stepchild. We really need to do something about this. And it looks like we're looking at deja vu over again. It wasn't that big. I can tell you, if I look at Alabama, they have numerous people. I actually had a conversation with Director Chavez about it. they spend a lot more money than we do. We're spending about $3.2 million a year in public funds auditing. They're probably in the neighborhood of $200 million. They have far more counties than we have. They have far more universities than we have. But they do a lot of audits. If you were to look at their website, they're probably, I would bet at this time in the year, they probably have 1,400 to 2,000 audits online. We're nowhere close to that. They may audit too much. I don't know. But here, we have a dichotomy where we look at all of our financial audits, towns, cities, governments, whatever we look at, they all look great. But if I look at Department of Audit audits, boy, some of those, like Manderson, are alarming. Bear River, they just basically said they're not going to do anything. I looked at Highland Hanover in Washakie County. Their response to the Department of Audit was, we agree with some of the things you said. We don't agree with some of the things you said. We might act on some of them. We're not going to tell you which ones we agree with. We won't tell you which ones we disagree with, and we're not going to tell you which ones we're acting on. That was their answer. You do need some teeth. Maybe I'll offer a suggestion. Forced transparency. They fail an audit with so many findings, it all goes on the Department of Audit's website, all their transactions, all their contracts. You just make it transparent until they fix everything. That might be the way to do it. I don't know. But we do have that problem as well. And the legislature should really discuss what needs to happen to get these things corrected. The local people would love the forced transparency. Senator Smith's comment about trust, that might solve his problem. It'd be an interesting solution. Does that, Mr. Chairman, Senator Larson, I did enjoy reading all that, the examiner's files prior to no longer being the examiner. It was very interesting. He did an audit of Rock Springs and found the very same issues that you're seeing in Bear River, in Manderson, not to the same extent, not to an alarming extent, but they weren't managing the utilities very well, the water and the sewer. These things exist over time. It's deja vu all over again. And until we get those kind of audits going, we may still have that trust item Senator Smith was talking about.
All right, follow up. Any other questions? Thank you so much for your testimony. Very good words of wisdom.
Thank you, sir.
All right, is there anybody else from the public that would like to speak? Anybody online? Okay, does anybody need a break? No, we'll push forward. Okay. Yes. Representative Lean.
Thank you, Mr. Chairman. I just wanted to take a moment and offer a motion. Given our ability to be able to review our duties to conduct audits, I would like to make a motion that we subpoena Riverton Recreation District Number 25 and the Fremont County Clerk, the town of Bear River, their mayor, clerk, and treasurer, and the town of Manderson, the mayor, clerk, and treasurer, to all come to the Management Audit Committee and explain why we haven't found any compliance.
Second.
Third.
All right, any discussion on that motion? Yes, Senator Ide.
So is that sort of a dragnet from each one of those counties? Do we need to name them specifically to come to the management audit? That's my only question. Thank you, Mr. Chairman.
Representative?
Mr. Chairman, I just don't happen to know their individual names at this moment. So I believe that it is specific enough to know that the mayor of Manderson is one individual and that that could be put on the correct subpoena paper.
Mr. Anderson, do you have a comment on this?
Mr. Chairman, just a note, I don't know that we've used our subpoena power a lot, and the approach we've taken in the past is to just first invite them to come, and then if they don't come, then we subpoena them after. And just a comment, Mr. Chairman.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. So this committee has the authority within state statute, and I'll cite 28.1.109 and 28.1.109 again, where we talk about issuance and service of subpoena and privilege to witness fees and expenses is that title. I think it's important, I'll just speak to the motion as I did second it. I'm deeply disturbed by some of these audits that we have been provided by the Department of Audit. I can tell you that families in my community work very, very hard right now to put food on the table and to pay their taxes. And it is absolutely, I'll say it again, mind-boggling when you have a state-funded town or an entity such as the Recreation District that receives state funds, giving the Department of Audit and the legislative body essentially the middle finger. People work too hard in our state to pay their taxes. It's unacceptable, especially when the hands are tied of the Department of Audit when it comes to enforcement. And so this committee, I believe, is the appropriate place to address the issues that the good representative has brought forward through the motion on and forth.
Any other comments? Okay, all those in favor of the motion, please signify by saying aye.
Aye.
Aye. All those opposed, no.
No.
Motion carries. Yes, Vice Chairman Larson.
Thank you, Mr. Chairman. I'd like to propose or ask for a bill proposal on bringing the Public Funds Division of the Department of Audit into the realm of the LSO and have two separate, how was that stated earlier? Two co-equal directors, and that would be the division of them.
Okay, there's a motion on the table. Is there a second?
Bill proposal.
For a bill proposal. Bill draft.
Yep, bill draft. Sorry.
Okay, motion and a second for a bill draft to have it brought under management audit, or under LSO.
Correct.
For two equal positions there. All those in favor signify by, discussion, I'm sorry.
Could you explain a little bit more about why you're making that motion and just so everybody knows exactly where we're headed with that? Thank you.
Mr. Chairman?
Yes.
Thank you. I think it's in the Constitution that we have that duty to do that. And also in the statute that we have that duty. And I'm not sure if having the executive branch audit the executive branch is the proper role of that department. So I guess that's my main concern. I don't know if that explained it enough, but I think we as a body should be doing that.
Similar to what Senator Rothfuss had said before, I think. It is, I'll just say this, that this committee for a long time has kind of been, I won't say neutered down, but has let itself be kind of negated. And it's nice to see it step up, and I think we've picked some of the worst violators of their audits to come before us and at least be accountable to the people. This is taxpayer money. This is taxpayer money. And so I think this committee has an obligation to make sure that that taxpayer money is being spent properly and that people are held accountable to it. So I do see this as a positive motion, so. Any other discussion? Senator Smith?
Just to clarify, so then the motion is to draft a bill. This committee would
Yes,
have
this is a
LSO
bill
draft a bill. And we'd have two separate but equal positions and then departments within the LSO. We'd have Director of Office and then the Department of Audit, correct?
Correct.
Okay.
Is that
Yeah.
correct? Yes.
Okay.
All right. Any other discussion? All right. All those in favor, please signify by saying aye for a bill draft for next meeting. Aye. All those opposed? Okay, motion carries. Is there any other discussion on topics? I have one, and as we're talking about performance auditing and alternative means to achieve results, which is another directive, do operations align with legislative intent? We had a situation last year in Weston County in our elections, and it could have happened in any county. It resulted in just a disaster. And so I would like to use the department or use this committee to at least take a look at the facts of that situation. If anything, the reason I would like to do this is we have an obligation to look at our current statutes, see what went wrong, see where we can improve on those statutes. We're not a body that will decide anything, but we are a body that can at least do a findings of fact. I think it will be very easy to do in interviewing. It'll be very easy to do in seeing what has been turned in for audits in that election. It is not a witch hunt or trying to go backwards in time, but it is moving forward to see where our statutes broke down. This was a serious, serious issue. And I think that we owe it to those constituents and the voters of Wyoming to look at this and say, what statutes were in play? What statutes maybe didn't get carried out properly with the intent that they were meant to, or what we need to add to statute to do this. So my goal is to just, at the end of this, have a findings of fact that we can present to either other committees or to authorities that it needs to go to, including our AG and governor. So that is it's a discussion item only. I just wanted to see where this committee fell on this topic, to see, number one, if it's under our purview, that we can pass this on to other committees and at least do a findings of fact, and to see if this committee would like to move forward with a subcommittee perhaps, so that we don't expend extra time, extra money for our staff to just gather those facts and at the end of this have a finding of facts and not a conclusions of law, but just a way to make things go better. So with that, I would entertain discussion. Representative Lean.
Thank you, Mr. Chairman. I just want to say that I support your motion or your discussion to be able to review the process, that in addition to financials, we should also be evaluating the rules and the processes that are working well statutorily and that are not.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. I agree with the good representative. I say let's get a factual document to pass on to the Corporations Committee. I will, if if you're accepting motions, I would make a motion at this point unless you'd like to continue with discussion.
Is there any other discussion? And I do respect, we have senators here that have been here quite a long time. And I do think these things are important to look at, but I would welcome any other comments. Oh, all right, before we have a motion, because we're in discussion, we'll go ahead and hear from the Secretary of State. Sorry, I didn't see you sitting there.
Good afternoon, Chairman and members of the committee. I'm Chuck Gray, the Wyoming Secretary of State. I'm joined today by our office's Policy Director and Counsel, Joe Rubino. Seeing this on the agenda, I thought it was important to speak to my experience as the Chief Election Officer of the state of Wyoming in the 2024 general election, and our office's independent investigation and report released in March concerning the conduct of the Weston County Clerk, Becky Hadlock. This led to a referral of complaints regarding possible violations of law of the Weston County Clerk pursuant to the election code, as well as a recommendation to Governor Mark Gordon recommending removal in accordance with 18-3-902. Ultimately, the governor did not proceed with the 18-3-902 process. I want to alert the committee to my concerns, which still remain, pertaining specifically to the Weston County Clerk's submittal of a false post-election audit, which was never discussed in Governor Gordon's declination to take any action under 18-3-902, something that I'd certainly be supportive of the committee looking at further. While a report contained a number of findings based on the conduct of the Weston County Clerk, specifically surrounding her errors leading to ballot misalignment, incorrect tabulation, and incorrect unofficial results on the night of the 2024 general election, I want to point out that those original errors did not trigger my recommendation for removal. But the most important problem we highlighted, and the problem that guided our recommendation for removal, was the Weston County Clerk's submittal of a false post-election audit report on November 6th, which was later revealed by the hand count at the Weston County Canvassing Board meeting and the subsequent post-election audit that occurred over the subsequent weekend. Now, the post-election audit is in state statute, and it's supposed to be an examination of the ballot image of a selection of ballot images with the cast vote record, or how the vote was actually cast. So you think about it, it's a photo of the ballot versus how the machine cast the ballot. So clearly that first post-election audit, which is why it's in state law, should clearly catch the alignment error. This false post-election audit occurred after we had expressed concerns about the anomalies in 2 separate meetings. So just digging into that a little further, upon noticing the highly unusual discrepancy of undervotes for House District 1 on election night, I attempted to contact Clerk Hadlock via telephone shortly before midnight. And after multiple unsuccessful attempts to contact Clerk Hadlock via telephone, I contacted the Weston County Sheriff, Brian Colvard, directly and requested Sheriff Colvard locate Clerk Hadlock. Following this request to the Weston County Sheriff, Clerk Hadlock eventually called our office back, and when asked about the discrepancies concerning the House District 1 race, denied that there were any irregularities in the vote totals. I indicated my concerns with the anomalies and calls on the evening of the election again, as well as the following morning of November 6th. And both of those occurred before any post-election audit had been filed with our office. Our investigation came to the conclusion there are only 2 reasonable explanations for the false submission of this audit, absent another explanation provided by the Weston County Clerk, the governor, or any other relevant actors, and I've invited all of them to provide an explanation. Our investigation found that one possibility is that Clerk Hadlock conducted her audit, finding errors in the election and then choosing to falsely assert that no errors have been found. That's one option. A second reasonable possibility is that no audit was conducted at all. And again, if anybody has another explanation, certainly would invite them to put that explanation forward, and we would invite the Weston County Clerk to respond. But that has not occurred. And the governor acknowledged that in his findings, that she had not responded to any request to explain herself. Either one of those possibilities would suggest highly problematic conduct in the aftermath of the 2024 general election. And that is why we made the recommendation that we did. And the governor's omission of discussing the false post-election audit in his decision is inherently problematic. And we reached out to him when we submitted our findings highlighting the false post-election audit. We had emails to them after we submitted our findings where we said this is a very important issue. And I want to emphasize again that the governor did not include any discussion of this issue. In my opinion, the most important issue in his letter regarding the Title 18 process. So appreciate you looking at this. I think Mr. Rubino was going to hand out our full investigation. It's about 100 pages with the exhibits. And appreciate it. And if there's any questions, thank you.
Thank you, Mr. Chairman. Mr. Secretary, Mr. Rubino, thank you for being here. Just one quick question. Has your office ever received any formal letter or call or anything from the Attorney General's office stating that they declined to prosecute?
I do not, thank you, Mr. Chairman, Representative Rodriguez-Williams. I do not believe so. Thank you. We're not aware of any.
Okay, are there any other questions for the Secretary of State's office? No? Okay, thank you. Any other comments? Yeah, and I'll just make one more again. So we had several, I think, deficiencies. One was the ballots. I understand that was probably a mistake. The focus I have is where did we fail statutorily in the audit process? And having that oversight for that compliance. So with that, you can make your motion.
Mr. Chairman, I agree with the concerns that you've shared, and I believe that there perhaps is it's appropriate to move to create a subcommittee in this instance. So I move that a subcommittee be appointed by you, Mr. Chairman, to receive or compel testimony, investigate, and produce a comprehensive report, specifically to findings of facts and conclusions regarding the post-election audit that was submitted by the Weston County Clerk after the 2024 general election and the administrative process used to investigate and adjudicate consequences for those actions. And I'd be happy to repeat if needed.
Thank you, Mr. Chairman. Now, are we voting specifically just your motion for the Weston County situation and the subpoena that would maybe required that we voted on earlier? Do these kind of play in together? Would this be a subpoena to the specific people of Weston County to come and testify in front of us? Thank you.
Does that answer your motion?
Mr. Chairman, Senator Ide, the motion is specifically that a subcommittee be appointed by the chairman. And I think that perhaps in regards to your question regarding subpoena power, being members of the Management Audit Committee working within a subcommittee, that that could be perhaps under the discretion of that subcommittee, or if the chairman felt like perhaps at a later meeting of management audit committee at large, the subpoena would be appropriate. But as of now, it's to create the subcommittee for those specific reasons.
Not here.
Can we discuss without them here?
Is there anybody that would like to discuss the Wyoming Business Council or anything that had to do with this topic? Or Senator Larson?
Mr. Chairman, I think I was the one who probably brought this forward. I think in discussing this with the Wyoming Business Council, I think they were going to give us a little report in October meeting. I specifically would like to hear how some of these programs they administer percentage-wise, how do they perform, years later after they're doing things. Specifically, there's a Business Ready Community Grant and Loan Program, financing assistance through partner members or institutions, startup business grants and loans, expand business grants and loans. I think those are the ones I was looking at specifically. And, I think there was a funding in Laramie on some things that went on, and I think, I'd like to know what happened in that area on the agribusiness, growing crops vertically and such. Up in Cody, we had things going on pharmaceuticals and dollars that were awarded. I don't know if they were used, but all those, I'd just like a report.
Any other comments? Would it be appropriate to invite them to our next meeting and give them those exact topic items to discuss and be questioned?
Mr. Chairman, I think I have talked to a representative there with Mr. Petrie. Maybe, I can't remember if we didn't do that a couple months ago. And we'll hopefully contact them again. I think they are aware that we would like them to come and speak.
Okay. All right. Yes, Representative Lean.
Mr. Chairman, on that topic, could I also request that the Wyoming Business Council give us a project total that they've paid out in the last 5 years, and if those projects are still successful or if they've gone bankrupt?
All right. Representative Sherwood.
Thank you, Mr. Chairman. Knowing that October is our last meeting, we may run out of time. This committee's doing a lot of lifting. I would encourage everyone to read the Business Council's annual reports. Those are on their website. And not wait for them to give us the information, but go and find it and read it and understand it for ourselves so that we're more prepared and that we can have those conversations in a timely manner.
Thank you. Any other comments? Anybody in the public care to comment on that? Hello, Senator. Please introduce yourself and.
Candy.
Mr. Chairman, I may not be the right time because I thought that's what I want to bring, so should I let you finish?
No, this is fine. Is your mic on?
Sorry, Mr. Chairman.
Okay, let's start again, and then you can go into whatever topic that you wanted to comment on.
Thank you, Mr. Chairman. Anthony Bouchard, coming to you as a taxpayer. I brought some handouts for you guys. I've listened to all the discussion about the conundrum of actually doing audits between one branch and another branch and all the problems that could happen. But what I want to bring to you is the real problem of not taking it serious. Not taking it serious that you have to do independence in audits. And if you don't put policy in place, what I'm about to present to you is what happens. And it's dark. It's really dark what happened in this story here. So I don't know which one you have on your top of your stack, but could we start with the one you see, Wyoming Department of Health? And you'll see there is a letter there to the FBI. And the reason that letter had to come about is because the director of quality assurance for Medicare was getting shut down. In other words, they were not going to move forward with an investigation at the state level. And so if you look at this letter, he's actually directing it to outside law enforcement to investigate. And it was right after this that this employee of the state got fired because he would not comply with his orders to shut down the investigation. And what I have attached to this is on the next page, you'll see the Powell man indicted on 234 counts of healthcare fraud. On this initial run, when they brought it to court, it was just under 7 million. And you'll find later in a document, they actually had, since they had stopped investigating, there was a big window where there was a lot of information that was lost and not able to bring back to the table so they can investigate it properly. But let's just go with the 7 million for now. So there is an attachment on the back of this. It just talks about what happens when independence and audit and investigation are not observed. You know, what's interesting about this form here that I got off the state website is it actually talks about how there was an obstruction. But what it's not telling you, because this is the state executive branch that made that last page, it was their obstruction. It was not the doctor's obstruction. By this point, they had already went up there, took the state plane, got the computers, had possession of all the information they needed. And if it wasn't for this man that got fired, if it wasn't for him taking that evidence and turning it over to the feds, Dr. Conti would have never been prosecuted. He would have never served 3 years in prison. He would have never been ordered restitution. So, like I said, that's just the basic part of the story. If you'd pick up the next part, it says United States District Court. The only reason I attached this front piece, as you can see, it says, "Dear Mr. Gaskell, the U.S. District Court has identified you as entitled to restitution. Now, this isn't a lot of money, just so you know. This is just almost a stipend because he's the guy. If you look at the actual paperwork in this court case, it says United States of America versus Dr. Condi. It actually has his business name in it too as well. But it also had Mr. Gaskell's name on it right below United States government. And the reason is because he was called a relator. And what that means in layman's terms is they could not have prosecuted the case without Mr. Gaskell, the man that the state fired. So understand that at the time, the governor at the time was also pushing for Medicaid expansion at a time that we had almost $7 million unaccounted for. And what we do notice from this whole case is there just wasn't enough zeal in the executive branch to look for these anomalies in the paperwork and in the numbers. And understand how this case, what would happen is this doctor had a whole umbrella of caregivers, and most of them weren't licensed, but he was pawning off these young people as for clinical work and giving it to these other providers that weren't even licensed, but yet he was billing Medicare top dollar. So that's what the basis of this case is. If you look on this federal, on the back of the federal sheet, this is a timeline of everything that happened during that case. And, if it's kind of a little bit detailed, but it goes all the way up and then all to the end where he was terminated. So understand this is the dark side of government where can the fox guard the hen house? I think this says no. I think this is evidence that that's not the case. Now, when I was on, and one other thing that I want to stress on this, I was just one legislator that was brought this complaint. And it was like I was powerless. I was on this very committee. I heard all the things you guys heard, that you guys don't have any power, you can't do this, you can't do that. Well, if this committee isn't here to do the things that need to be done, then who is? And who can, there are several people inside of this office that could have probably testified had they known they had somebody that had their back. So understand that is a reoccurring problem in government. People won't come forward because there isn't a process. So that has to be part of what this committee does. This has to be a safe haven for people in government that have been wronged or see something being wronged, and they have to have somewhere to go. I would urge the committee, like I did when I was on it, to develop a mission statement of what this committee does and write it in statute. And matter of fact, that's how I got on this committee. I actually drafted a bill to make a committee that was holding the government accountable, and they stuck me on this committee. They killed my bill, but they stuck me on this committee. And then we went along of all this tamping down every time there was an idea to investigate or do anything. So on the last piece that I have for you, there's an article that says former state Medicaid watchdog accuses health officials. Now, understand this, the reason this got in the media and even came out is because the good chairman of Labor and Health gave us a lot of leeway to bring this employee in and ask him questions and let him answer those questions. And this is pretty detailed on what did happen. And if you need more information on this case, I can get it to you. But understand the reason I'm bringing it isn't to drag out something that just happened and it's old, but just the fact that how do we fix things? This never got fixed. This man never even got a thank you from this state for doing this. And understand that his wife was fired. She was a state employee. They were both blackballed. They had to leave this state. This man was wronged. The people of Wyoming were wronged. because that's Medicaid money that was taken away, and there were people that didn't get it because there's only so much. So somebody was probably wronged on the receiving end that probably really needed help. So anyway, I'll leave it with that, Mr. Chairman and members of the committee, and I'll sit for any questions.
Mr. Chairman.
Senator Smith.
Welcome, Senator Bouchard. Thank you for being here. I had a question for you. I really appreciate what you brought, and you said something about the fox guarding the hen house. And just so you're as knowledgeable of Wyoming government, just about anybody that I know. So is one branch of government auditing itself? Is that the fox guarding the hen house, in your opinion?
Mr. Bouchard.
Mr. Chairman, well, I didn't want to get drug into that argument. So look, I can see both sides of what's on that argument. So you're going to put me on the spot, so I got to answer it truthfully.
Mr. Chair, Senator Bouchard, you said fox guarding the hen house. So I wanted to know what you meant, and if the fox guarding the hen house is one branch of government auditing itself.
Senator Bouchard.
Mr. Chairman, you know, I do get where you're going, though. I'm not looking at it the same way you're looking at it, Senator Smith. What we have is money that the legislature legislates, and it actually says, hey, take this money and do something with it. And then when the executive branch fails to do it properly, it's this body's job to say, hey, we're going to rein you in, and if you come in here and sit down and let's see what's going on. And then when you find out that something's been wronged, you have to take some kind of action. And a lot of times that becomes the power of the purse. I mean, that's how, I wish there was a way we could say, hey, we could call the cops and have somebody arrested. That's not always the case. So, I don't know if that answers your question, Mr. Chairman and Senator Smith.
Mr. Chair. Thank you, Senator Bouchard. I think it's a good answer. I see what you're saying, and thank you for being here. I have to say that you look much younger now that you're not in the legislature.
Any other questions? Thank you very much. I
Hey, thanks for
appreciate the
having me.
All right, are there any other discussion items or issues to come before the committee? Yes, Representative Lean.
Mr. Chairman, I'd like to ask LSO if there is any specific wording that they need to issue the subpoenas, or if there's any verbiage that I missed, or if it's clear. Is there any clarity from LSO?
In fact, let's just read back directives from today, just so that we have all the votes and all the direction.
Mr. Chairman, so I had a motion to direct LSO to request the Department of Audit to conduct a performance audit of the LSO. I have a motion to do the subpoenas, and I believe the other staff here had that specifically, but if we need any clarification, we'll get in touch with the chairman and with the movement as well. We had a motion to draft a bill to move the Public Funds Division of the Department of Audit under the Legislative Service Office with 2 directors. And then we had a motion to create a subcommittee to produce a report and finding of facts related to the Western County Clerk issue and the process to investigate, or the process of investigation and adjudication of that. That's what I had, Mr. Chairman.
All right, thank you. Representative Lean, did that answer your question?
Yes, Mr. Chairman, thank you.
All right, any other discussion? Vice Chairman Larson.
Mr. Chairman, I think we're, future meetings and adjournment is on the next item. I would ask if the next meeting be in Casper. I don't know if that's possible, but I would like to ask that.
All right, well, maybe we better take a vote on that.
Probably get overruled.
We'll check availability, I guess, with LSO like we did this meeting and see. Does anybody have any objections to that?
Yeah, I'd rather have it in Powell.
All right, well, we'll check on that. All right, seeing no other items, this meeting is adjourned.